again, assuming we held the hearing today, found a violation today, and we would, without the respondent present, we're having only your side of the story, and that makes it difficult for us to really to reach a decision. So, do you still are you still going to ask that we hear this today, knowing?
I'm here. I drove 2 hours to be here. I don't know if if they're not here to respond, then you guys can't hear their side of the story.
Mm-hmm.
So I don't know even what that means at this point.
Okay. Both of you, please be seated. What is the feeling among the members of the task force? Member Washburn, and then Member Chan, Member Snyder.
Well, one thing we can find them in violation, the district attorney's office, for not sending somebody knowledgeable about this. This matter's been going on for a very long time. And then it would go to the complaints and amendments committee, which would kick it back here the following month. That might speed up the process.
Well, it wouldn't speed up the process in time for election day.
No, it won't. It won't. I mean, absolutely not.
Member Chan, Member Snyder, Member Kneber.
The one thing is, if we do vote today, right, I have to excuse myself because I know Kamala. I worked in her campaign before, and I'm a supporter of Kamala Harris. So.
Okay, so if we have the hearing today, we would need there are 3 members who are not going to be showing today, and if we get no other members and Member Chan has to recuse, that leaves us with only 5. So, and that is not a quorum. Member Snyder, Member Kneber.
Yeah, I mean, this is an important and complicated issue, and it's really unfortunate the DA's office didn't see fit to send one of the 3 knowledgeable representatives that they could have sent. But there's not a lot we can do without the DA's office here, and I don't know whether they knew that, but I suspect given the proximity of the election, they did. And I would just emphasize that it's really unfortunate that they saw fit to not send anybody. I find it hard to believe that was impossible.
Well, at the complaint committee, Mr. Patel told us that Mr. Henderson had an outside commitment that would make him unable to be here, and Mr. Patel also told us that Mr. Henderson is really the only person knowledgeable in this matter.
Okay, I didn't know that.
Member Kneber?
I'll echo what I said at the complaint committee. It just troubles me that this is part of their job, and they should have somebody here, and I see no reason why we should excuse them from doing this. As Mr. Patel said that he can respond, he could be here, but because he has other court cases that he had to work to, and I understand that, but I'm sorry, it's part of the district attorney's duties to send somebody to sunshine meetings, knowledgeable people, and I just don't think that we should let them get away with this.
Member Johnson?
I am not in favor of continuing it because it does seem suspicious that they waited 4 months, especially based on the election, and it would be rewarding delay because I don't think they really care whether the documents come out as long as it's after the election. So even though we can only hear one side, by continuing it, we're going along with the practice of not showing up in order to avoid answering.
Member Snyder?
I would agree with you, Member Johnson, except in this case, what we would be deciding is whether what the DA's office has done is within the rule of reason, and there are a lot of facts that we would need to find, in my view, in order to properly make that determination. And the facts that we need to find, we really can only find from the DA's office. We would need to ask them what they have been doing in order to comply with her requests and whether they've instituted any procedures routine procedures which demonstrate that they've been doing something to comply with the request. And in the absence of anybody here to answer those questions, we can't, in my view, make the determination.
But if you continue it based on those reasons, the next time we need something from them and they don't want it to come out after a particular date, I agree with you that it would be hard to make a determination, but by actually putting on the record that we chose to continue it, I feel like we're condoning their lack of having somebody show up after 4 months.
Well,
So you could still, if we hear it because the complainant is here, at the very least we would be finding them in violation of not.
yeah, I think, in my view, we can find them in violation for failing to send a knowledgeable representative, but beyond that, I don't know that there's much we can do. I would ask the chair if, is that a procedural possibility, that we find a violation of 6721E, but continue the rest of it?
Well, if we decide not to continue the matter, certainly that is possible. Again, that would depend, of course, on whether Mr. Wolf is here by that time, because if we have one recusal, that leaves only 5 of us, and that's not a quorum. Based on the conversation that has just taken place, I am inclined toward leaving this on today's agenda, not withdrawing it, and if we have a quorum by that time, we will proceed with it. Whether we actually find a violation on the complaint itself, that will remain to be seen. But if we have a quorum to continue to proceed with this today, we shall do so. I will ask at this time, are there any other changes requested to the agenda? Sir.
Yes, sir. I'm Howard Lazar with the Arts Commission. I'm with number 8 on your agenda.
Yes.
And I just have to tell you, I have to leave at 5:45 today.
Okay.
Okay.
Thank you.
Thank you.
Anybody else? Sir?
Mr. Wright, I'm number 7, which
Yes.
would be the first person to be heard, and this matter that pertains to me and the Human Services Agency is going on, or about maybe the 3rd or 4th month, and it's been a continual time delay by the Human Services Agency.
Sir, right now we're talking about any requested changes to the agenda. Are you requesting a
Right.
change in the agenda?
So I'm requesting no changes and have me heard
Okay, thank you.
first.
Any further requests for agenda changes? Seeing none, would you, Mr. Clerk, could you call the first item, please?
Item number 1 is the approval of the March 30th, 2010 special meeting minutes.
Is there a motion to approve the meeting minutes of March 30, 2010?
I so move.
Is there a second?
Second.
Moved and seconded. Discussion. Okay. Is there any public comment on the minutes of the March 30, 2010 meeting, special meeting? Seeing none, I have some minor corrections. They are not substantive. I will send them along, and there is no need to delay action on this motion. Roll call, please.
On the motion, Member Snyder?
I'm sorry, what was the motion?
Motion is to approve the minutes of March 30, 2010.
Yes.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Member Knepper?
Aye.
Knepper, aye. Member Wolf? Wolf excused. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
All right.
Nee, aye. Mr. Chair, we have 6 ayes.
We have a quorum, ma'am. Read the next item, please.
The second item is approval of April 2010 special meeting minutes.
Is there a motion?
I move we approve.
Is there a second?
I second.
Discussion? Is there public comment on the minutes of April 20, 2010 special meeting? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Member Knepper?
Aye.
Knepper, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes.
Okay. Before we proceed with item number 7, I'd like to ask the administrator what's the progress on the minutes of our last regular meeting on September 28th.
I'm still working on that set of minutes, Mr. Chair.
Okay, thank you. Next item, please.
Item number 7 is the task force has asked Human Services Agency Executive Director Trent Roher to appear and explain why he refused to instruct HSA employees to testify on file number 10030, Michael Wright against the HSA.
Okay, is Mr. Rohr present? Okay. Is there anybody here to speak for Mr. Rohr or for the Human Services Agency on this matter? Okay. Mr. Wright, if you have anything you'd like to say, please approach.
Good evening. Mr. Wright, this example, what we're experiencing here today is just another continuation. First of all, I'd like to review how we first came in contact with the complaint that was filed by me pertaining to Brianna Moore violating my rights pertaining to the Sunshine Ordinance. On our first hearing, Brianna Moore failed to appear. The Sunshine Ordinance ruled that there was a violation because there was a body that should be open to the public. As a result, we gave Brianna Moore a chance to come at the following meeting, which took place a month later. At that meeting, we received documentation from Pat Tebow, a lady who I'd never come in contact with, who tried to cover up the fact that Brianna Moore did not appear at the first meeting, claiming that there was a restraining order filed against me, and I had to stay 50 yards away from her, and I was not allowed at these meetings. So as a result, the following month, I had to demonstrate that there was no restraining order to justify the statements that was made by Pat Tebow. In fact, the judge at that hearing denied their request and told them that they can't stop me from coming to the shelter monitoring committees, the directors' meetings pertaining to the shelter system, and the Homeless Coalition Board. In fact, the judge also told them if they feel that they're scared of me and their blood pressure goes up high when they see me talk, stay away from Mr. Wright. And if you see Mr. Wright in the elevator, if you're scared of Mr. Wright, don't get in the elevator with Mr. Wright. You cannot stop him from coming to these meetings. He's advocating for himself and people who are economically disadvantaged. I demonstrated in front of the judge that I represented one client and took him to a small claims court because of the same type of violations that I was complaining about, and got him approximately $2,100. Brianna Moore and Joyce Crum were doing nothing more but retaliating against me because I was demonstrating that they're in violation of their own rules and regulations, and they're supposed to be the executives and the managers pertaining to the Human Services Agency Committee, okay, an agency. And then after that fact was demonstrated, then we issued out a violation pertaining to the Sunshine Order 67 series of law. In fact, the complaint was also ordered and forwarded to the Ethics Committee. Then we gave Brianna Moore and Pat Tebow an additional chance to appear a following month. On that month, she failed to appear again, and this time Trent Royal tried to cover for Pat Tebow, further demonstrating their domino effect as I and the task force goes up the chain of command and proving that they're not dealing in good faith, and by the same response never had any intentions on reaching a legal agreement on this matter. There was controversy on should the task force issue a order of violation of the Sunshine Ordinance as we did pertaining to Brianna Moore and Pat Tebow. The task force decided to give Trent Royal a chance to appear, which was supposed to be this day as we speak, as I speak here today. Now we get the city attorney's office trying to cover up for Trent Royal in the way that the chain of command, which caused us to be here today. Now, today, since Trent Royal failed to appear, I'd like to have the task force issue out an order in my favor and forward it to the Ethics Committee as we did with Brianna Moore and Pat Tebow. And by the same response this time, the city attorney's office is joining in on this discriminatory practice and trick and device by means of submitting a document that's dated today, October 26. Now, we've already concluded that there are a government body and they have to be open to the public. Their own document shows where it says under background, which reads all in detail as follows in part. This office is informed that Michael Wright has filed a complaint with the Sunshine Ordinance Task Force regarding his attendance as a member of the public at the regular scheduled meeting of the, now the following demonstrate that they're a government body and it must be open to the public on the grounds that they list directly in detail housing and homeless division shelter and resource center directors group, and then they write down group in parentheses and inform the program manager of the housing and the homeless division and the homeless and the human services agency program manager, other staff within the homeless division and the contractors of the agency that provide shelter services and resources centers services in the city created the group. We are informed that the group does not allow individuals and organizations other than its members to attend the proportion of the meeting which Mr. Wright complained about. We also,
okay, Mr. Wright, your 5 minutes have expired. Could you conclude, please?
Okay, I conclude that this demonstrates how they're not demonstrating and dealing in good faith because they are a body that must be open to the public. And by the same response, they're undermining me and they're trying to undermine the task force by saying that they open the second half of their meetings up to the public when they already had their minds made up without getting the input to show how their rulings treat the clients that are using their services.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Okay, seeing none, we have already called for the respondent and supporting facts and evidence for that side, so the matter is back with the task force. Member Snyder?
I don't see that there's a lot to do except potentially find Mr. Rohrer in violation of failure to appear under 6721E.
Okay. Is there any sentiment toward sending this matter on to ethics or to another enforcing agency, another enforcing body? Member Knebber?
Well, I mean, last time we had this long discussion, and this is what I thought we needed to do is actually ask him to appear before we can find violation. I think we have to find violation and then refer it to compliance committee, and then if still, then we can, in my opinion, then we can refer it to ethics after that.
Okay. My recollection is that we actually did refer this to compliance and amendments. After we found violation, we instructed the respondents to draft some kind of statement as to how they intended to abide by the Sunshine Ordinance, particularly the passive meeting applicable sections going forward. They did not do that. And we that's one of the things that brings the matter back before us today.
Okay. Well, then, that being the case, I would support forwarding this to the ethics committee.
Okay. One of the things that I think we have to consider in voting whether or not, in deciding whether or not to refer this, is the October 26th letter. Apparently, the directors group and the Human Services Agency have received city attorney's opinion that the directors group is not a passive meeting body. We have heard that we decided, the task force decided, I believe at our last meeting, that it is, that based on all we've heard and seen about it, it does qualify as a passive meeting body because it does have an influence on the shaping of city policy. Another thing that we should weigh is the date of this memorandum from the city attorney's office, from Deputy City Attorney Williams. It's today. There is no reason to know, there's no way to know one way or the other whether the Human Services Agency or the Directors Group or anybody else had this particular advice in hand at the time they were responding to Mr. Wright's complaint, or before that, whether they were barring Mr. Wright, keeping Mr. Wright away from the meetings. This is kind of a Johnny-come-lately memorandum. I think that's something we should. So this again raises the question of whether they were in fact acting on city attorney's advice when they prevented Mr. Wright from attending and speaking at the Directors Group meeting. Member Wolf.
I would just say that looking at in the past of all the communiques from the Human Services Agency, they all came a day or so just before the meeting without providing ample time for people to, either the task force members or the complainant, to review.
Member Johnson.
This is sort of a side monkey wrench to throw into this, but I've brought this up once before. 67.21E talks about making public records available. And when we had discussed it before, you had said that Member Craven Green had previously said that we would let them know that we had extended it to include if you didn't show up for matters related to meetings. But in the memo, I just want to point out, because I would like to have Mr. Wright have some, justice in what happened to him. The Ethics Commission in Member Cawthon's complaint, they specifically state that they will not recognize 67.21E if it's associated with the ability of an individual to make public comment, not the withholding of public records. So if it were sent to another committee, perhaps there would be some way to address that if we I'm not saying we shouldn't forward it, but some way to address it, because they're clearly stating here in this memo that they're not going to acknowledge that as something that's under their ability to punish them for.
Is there a motion to refer this to ethics, and if so, or to another enforcing body, and if so, what do we want to say in our forwarding message, Member Snyder?
Taking into account Member Johnson's remarks, we could, in our order of determination, specify that the task force has a pattern and practice of applying 67.21E to not only public records violations but open meetings violations as well, and that that pattern and practice establishes, or has established, that a failure to appear on a meetings violation falls under the purview of 6721, just as a violation of the Public Records Act does. I don't know. We can't change the Ethics Commission's mind, and if they decide that they don't view that if they disagree with us, they disagree with us. But we can explain why we think 6721E does apply here, and obviously it's up to the Ethics Commission what they do with that.
Well, there's also the substance of the complaint itself. Is the group a passive meeting body? Did they, in fact, violate the Sunshine Ordinance by failing to act appropriately as a passive meeting body? Did they, in fact, violate Mr. Wright's rights under Sunshine? Mr. Snyder?
I think we've already made a decision on that.
Yeah, and that's my point. This actually agenda item is really only about Mr. Rohr appearing or not.
Exactly.
I think that's all that we can talk about here.
Right.
And find.
We've already made the decision, and we've issued an order of determination. And subsequent to that, the city attorney has issued a memorandum which disagrees with us. and might include some information which may have changed our decision. But we didn't have that information before us, and we can only decide things with the information we have in front of us. But
So
the decision is made, and I don't see that I'm not. I mean, maybe people members who've been on the board longer than I have can correct me. But is there a mechanism for going back and changing something once we've issued an order of termination?
Mr. Chair?
Member Wolf.
I would just say you just go by Robert's rules. If you want to reconsider an item, somebody who is voted in the majority for that item can ask that it be reconsidered and put back on the agenda. If the body votes to determine that it be reconsidered, then it goes back to the point just before it's voted on. So more discussion could be taken, so on and so forth. But it's a process.
Did we have a motion yet?
We do not have a
No,
motion.
no motion. Okay.
In my view, Mr. Threet, does that comport with what you know?
Mr. Threed?
Through the chair, Chair Kenny, I believe that your rules of procedure address this issue, and I don't have a copy of those rules with me. And I'd be happy to take a look at them if I could get a copy from the clerk if you want me to take a look at that. But my rather vague memory of it is that it follows the standard of if there's some matter that was not brought to the task force attention, that was not available to the person seeking reconsideration at the time of the hearing, then they can bring that matter to your attention and you can decide to reconsider it and perhaps make a different ruling. But I believe, if I recall correctly, that it would require that in this case, the respondent come to you with that request first off, and then it would have to follow those criteria. Now, as I said, it's a vague memory of that rule, and I would prefer to review that procedure before firmly advising as to what your rules say about that.
My recollection is that if either complainant or respondent comes to us with new facts that we didn't have before, we can bring it back for consideration. If a motion for reconsideration wants to come from within the task force, it has to come from somebody who was on the prevailing side of the previous vote. Is there a motion to refer this to the Ethics Commission?
For a violation of 6721E for Mr. Rohrer's failure to appear tonight?
Well, also for failure to comply with the previous order of determination.
This part of the order of determination was him coming and showing up and explaining why that he ordered them. So that was part of the order of determination. So I would so move.
Well, also the failure to show the Compliance and Amendments Committee some kind of policy aimed at guaranteeing openness of the passive meetings and the ability of the public to participate. Member Wolf?
Well, my observation of this whole experience of this item is that he chooses to try to manage this from afar.
Point of order, we can't discuss this without a second. First of all, let's solidify the motion. Member Snyder made the motion.
I'll second.
No, I didn't. Did I
Okay.
make the motion?
Member Knever made the motion. Member Wolf second. Member Wolf.
Okay, so my concern about this whole thing, which leads us to this point, is that he chooses not to appear, tries to adjudicate this or defend himself or respond to this from afar, by remote, by paper, by proxy, or what have you. That's not proper. We have other members, staffers, members of the city family that are here today that showed up. He should do the same. It's his responsibility. And I'm wondering if some investigation as to whether he actually took the required sunshine training, and whether how that plays into this too. Having knowledge that he must appear, I think that's an important factor too that should be forwarded to the Ethics Commission as point of summary, that everyone in the city family, including ourselves, has the responsibility to know the Sunshine Ordinance and to appear when asked.
Further discussion? Is there public comment on the motion to refer this matter to the Ethics Commission? Thank you for coming, sir. You have 3 minutes.
Chairman Nee, members of the Commission, Ray Hartz, Director, San Francisco Open Government. This is wrong in so many ways. I don't think you could even sit there for 6 or 7 meetings and figure it all out and sort it all out. Basically, the city's position in these cases is if we can't come up with a reasonable explanation to justify what we did, then we'll simply not respond. We won't show up to the meetings. We won't send a letter. If we send a letter, we'll send it after the date in which you were supposed to consider it. Just so many myriad violations that it's unbelievable. And it really shows a disrespect not only for the commission or the task force itself, but for the citizens of the city of San Francisco, in that this is the law. Whether they agree with it or not, whether they believe it's right or not, whether they support it or not, it's the law of the city. It was passed by the voters with over 70% majority. So it's not something that they can, they just don't like it. And to simply not show up and then expect Mr. Wright to consistently come to these meetings, which he does, he makes a very good case to put forward. And basically the onus is on him to do everything. He doesn't. I mean, he's in a position of trying to guess what their defense is, because they aren't even willing to show up and make a defense. And to let it drag on and drag on and drag on, or to simply send it to ethics isn't going to do any good. Referring back to the Coffin case before ethics, ethics has said, well, unless you're a managerial employee, you have to be a managerial employee with certain responsibilities, or else they can't find you in violation. It becomes this long, as I said before, the long, drawn-out process of trying to make public comment or trying to get a public document, contrary to any good faith effort. And I think that is the key point here. There has been a totally bad faith shown in the entire process in this case. They have repeatedly not shown up, not responded, or given responses which are nonsensical if they are even responsive at all. And to allow them to just continue to do it over and over again puts the person who is the complainant in a untenable and horrible position. I think the second reason they do this is they simply drag it out and drag it out and drag it out, and then they come forward at one point and say, look at Mr. Wright. All he does is file complaints. He's abusing the system. And so he ends up being on the defensive, trying to defend himself from charges that come from their actions, not his own. And you need to find them in violation of anything you can find them in violation right now, in addition to any further referrals you might choose to do.
Thank you. Is there further public comment?
Yes, I have further public comment. Not only do I have to say ditto to exactly what he said, he's just absolutely parroting what I've been saying for the last 10 years to this commission about how worthless the entire process is. So now you can, wash your hands and refer it up to the Ethics Commission, which is going to disagree with you like the last times that you've referred something up, but you can wash your hands of it and say that you've done process and done the citizens good. And in my own particular case, this is the 5th month that I've been here, the 5th time about my particular incident, which was an immediate disclosure request, which should have been done in 24 hours because your procedure is full of false hope, riddled with false procedure, and then when you quote-unquote rule within the law so that you can wash your hands and push it up to the Ethics Commission overrules you, and everybody goes and has a beer afterwards and glad slaps everybody else and says, oh, isn't it just wonderful how the illusion is being carried on? It's beyond disgusting. So not only what he is saying am I agreeing with, I am the victim of the exact same thing, and I'm still waiting to hear back what punishment does result from sending something up to the Ethics Commission for a willful violation, whether it's intentional or non-intentional. But, of course, they can look into people's minds and knows when it's intentional. The whole process is beyond a farce. And as grown-ups in America, to be pulling this on the citizens, which you're supposed to be standing behind, and for him to be complaining and me to be complaining about the process and the lack of advocacy, gentlemen, I'm glad the maker is looking down on this.
Thank you. Is there further public comment on this item?
Good evening, Commissioners. I think this is a real injustice to the people. I mean, we come here for a tiny, tiny bit of justice, and then we get a slap in the face. They slap you in the face by not showing up. I mean, they should be taught a lesson. I mean, just slap them back and to teach them what this is all about. and protect the people. That's your job, is to protect the people. Thank you.
Thank you. Is there further public comment on this item?
Yes, my name is Peter Witt, for the record. Last year or so, maybe it was 2 years ago, actually I don't remember the date exactly, but the very same thing happened with me and the Taxi Commission. The Commission failed to send a representative to this committee, or body, as it were, and this body ruled in their favor without any evidence or defense to the charges, and failed to examine the evidence that I presented, which were a number of videotapes provided by SFG TV, or could have been provided to you at home with a simple computer. So I would reiterate, and I would be the third stooge here, and I would walk in lockstep with the last two speakers, members of the public, who you are sworn to protect and uphold the rights that we are supposed to have as individuals. Now, I just want to add further that when government runs astray, we are in serious trouble because there is no one else to protect us. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion? Roll call, please.
On the motion, Member Snyder.
Could I just clarify what the motion is, please?
Read the motion back, please.
Yeah.
The motion is to find Trent Rohr in violation of 67.21E and to refer it to the Ethics Commission.
Okay. Aye.
Snyder, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan.
Aye.
Chan, aye. Member Johnson.
Aye.
Johnson, aye. Member Williams. I'm sorry, Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Thank you. Next item, please.
The next item is hearing on complaint filed by William and Robert Clark against the Mayor, the Board of Supervisors, and the Arts Commission for approving an increase in the certificate fee for street artists when processing public document access requests is the purpose of the increase.
Okay. This is a continued item from our last regular meeting. Is the complainant here, please?
Good evening, members. I'm William Clark.
Again, thank you for coming. You have 5 minutes.
You're welcome. Thank you. Just to reiterate, my brother and I did not make this complaint on the basis that we are stating that the city does not have the legal authority to raise street artist fees to pay for legitimate administrative and enforcement costs of the street arts program. This complaint is based on the fact that the controller informed the Arts Commission that there was enough funds in the Street Arts Special Fund to pay for the fiscal year's administrative costs, enforcement and costs. I sent you an email this week, which I didn't have access to last week, which was from Mr. Consell to Ben Rosenfield of the Controller's Office, because before the Board of Supervisors meeting voted on this, Mr. Rosenfield informed the Art Commission that there was enough funds in the Street Arts Fund to pay for all of next year's expenses, as well as any expenses that would be incurred for this $17,000 increase. And at that time, Mr. Consell argued with the controller and said that he wasn't going to do that, that they disagreed with that, and that the only reason why that this fee increase was being implemented was to pay for processing Sunshine Ordinance requests to cover the staff time of the Arts Commission and the City Attorney's Office. And I remind you that under the Sunshine Ordinance, the City Attorney's Office staff does not even get involved in releasing a document or allowing review of a document until the keeper of the document determines that it's not for public review. Yet we're being charged, we're having every document and every request for public review sent over to the city attorney's office for analysis as to whether it's public, and we're being charged a fee to pay for that city attorney's staff time. And I would just like to remind you that as a street artist, and the Sunshine Ordinance says no fee shall be charged for making public records available for review. So even as a street artist, if I want to ask just to see a document, I am now being charged $47 a year to pay for the staff's time, the Art Commission staff time, and the city attorney's staff time, just to allow me to see a document. Myself and 400 other people are being charged this additional fee. So I think it's really important for you to take this serious, because any department can use this method as a backdoor method to intimidate the public not to ask for documents, especially relating to finances. We're having some serious problems trying to get some information regarding finances from the Arts Commission right now. They're still refusing to give us information about what they spent money on last year. And I'm asking you to realize that this is not just a normal fee that's being attached for administrative costs. This is specifically being charged us to pay for the staff time of both the Arts Commission and the City Attorney's Office. And as such, I feel that as a member of the public, I'm being told that if I ask for a document for review, that don't ask for too many documents, because if you take up too much of our time, and we're going to have to charge you money to pay the city attorney, we're going to have to charge all of the street arts additional costs and blame it on you. And that's a lot of intimidation on people who just want to find out how their money is being used. And I really don't have much more to say other than last month, other than I hope you had an opportunity to view the meeting at the Budget Committee meeting, in which the director of the commission clearly states that the only reason for this fee increase is to charge street artists this money to process these documents. And I hope that you find in my favor. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Hello.
You have 3 minutes. Thank you.
I'm going to try to play the video here. Can I address the street artist fee question? Yes, please. Thank you. The need for this modest increase in the street artist fee is actually...
Okay, we're having trouble with the audio.
Hold on a second. This was Director Chan's...
Two ordinances, policy ordinance, the first being...
We're still, Mr. Rustum is, I don't think that microphone is working.
Small staff of the Street Artist Program to spend an inordinate amount of time responding to questions, to provide documents, etc. Just as an example, from 2008 and 9 to the current fiscal year, the number of hours that the small staff of the Street Artist Program had spend doubled with respect to the number of sunshine requests that they had to do. In addition to the staff time at by the Street Artists Program, you have the city attorney's time that we pay for, and so and related to that sunshine ordinance. So that is the reason why we're seeking a $47.44 increase this year, for the next fiscal year, is to help pay for additional part-time staff to comply with the sunshine requests.
There was last year there was an increase as well.
Yes.
Current year. Okay. Thank you. Again, this is one of the items that we'll make a determination on later today. And thank you for your presentation.
I'd like to say a couple other things. My name is Mike Adair. I'm the chairperson for the liaison committee with the Street Artists. The Street Artists is a city program. It is self-funded by the members. We get no money from the city, absolutely none, and we have never gotten any money from the city. It's a real bone of contention with me that we never got any of the millions that go through the hotel tax fund every year. So, but that's a different story. But you can see Mr. Cancel said that the reason these rates went up were because of the city attorney time and the sunshine ordinance. I just did a small search today on Mr. Cancel with his ethics and sunshine ordinance requirements, and he hasn't done any of them since he's been employed with us since 2008. Also, there was no reason for this raise increase other than to put a chilling factor on asking for any more sunshine ordinance requests, because I have confirmation from the attorney after Mr. Lazar said there was no surplus. The last meeting, I don't know if you remember him saying that. That was a fantasy. I called the city attorney, I sent him an email, and I have his response back that there is $30,000 in there. So there was no reason to raise the rate other than to try to stymie us from asking for any more. And then just recently, I wanted to have a meeting to talk about this, talk about the finances, and have the chief financial officer with the controller. And Mr. Lazar said he would not consent to that. And I am the chairperson, he's the secretary of the meeting. So there is something definitely going on with this Arts Commission, and I don't think it's just with our program. I think it's systemic throughout the whole Arts Commission. And I would like you to find them in violation. And I have the paperwork here. I'm sorry, I don't have copies for everyone. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, is the respondent present, please? Thank you for coming, sir. You have 5 minutes.
Thank you, members. I'm Howard Lazar, the director of the Street Arts Program for the Arts Commission. And I just wanted to remind you that last March at your Education Outreach and Training Committee, that was March 11th, I informed you that my department would be correcting the problem of our frequent inability to furnish documents in a timely manner, that we'd be building into our budget the cost of hiring outside temporary personnel to assist in research and production of documents, and that the cost would be included in the license fee paid by all members of the Street Artist Program. And we did that. We kept our word in order to be in compliance with the Sunshine Ordinance because we were bothered by, thank you very much. We were bothered by frequently not being on time and having to run the rest of the program and all of our other duties. And we're just a two-person outfit in this program running it. The point is, though, and there was a transfer we found made recently by the controller. They transferred about $30,000 to our account from an unknown account. I don't have the account number with me at this point, but that's what happened. And so there was never a $30,000 that we'd been missing or not tracking because our chief financial officer had been tracking this year by year by year. And we put our faith in him, and to this day I'll still bank on what he says. But I'm not here to argue back and forth about the $30,000. What I'm here to say is, and with all due respect, that is moot. What I'm here to say is that it's not within your jurisdiction to adjudicate a challenge to a department's ability to set a license fee which reflects the costs of the department's operations. You were told this by 4 major legal sources. One of them was your Deputy City Attorney, Jana Clark, and then there were 3 outside free speech, quote, free speech attorneys. One of these 3 speech attorneys is the author of the 1993 Sunshine Ordinance itself. And all 3 attorneys stated in writing to Mr. Nee that the Arts Commission did not violate the Sunshine Ordinance by raising the street artist fees in order to cover city attorney and staff costs in fulfilling public records requests, and that the task force has no jurisdiction in this matter. To paraphrase, Attorney David Green, who's the executive director of the First Amendment Project, wrote, quote, "I see nothing wrong with this as a matter of law. The PRA and the SO bar an agency from charging a requester for anything but the direct cost of duplication. But neither law prohibits the agency from recovering such costs in other ways," unquote. Attorney Peter Scheer, executive director of the First Amendment Coalition, wrote, "I don't see a legal problem with an incremental increase in the fee or the stated reasons for the increase." And finally, Attorney Terry Frank, who's the general counsel of Californians Aware, and he's the drafter of the original language of the initial Sunshine Ordinance of 1993, he wrote in response to member Richard Nee's question of whether the fee and or the increase be construed as an illegal charge for handling public records requests. And to this he replied, "No, Rick, it's a completely different issue. Fees for obtaining licenses, permits, certificates, and other specific authorizing documents have always been regarded as a rational, appropriate service charge. And the only question is how big the fee is." Well, despite this advice from 4 legal experts of the Sunshine Ordinance, some of you at your last meeting argued against the advice. An issue was raised about Proposition K, that's the 1983 ballot ordinance, which allows the Board of Supervisors to increase the street artist fee to cover the Art Commission's costs in implementing the street artist ordinance. The point was made, as I recall, that the Proposition K of 1983 does not include any provisions regarding the Sunshine Ordinance, and therefore the street artist fees cannot be increased to cover the costs associated with public records requests. Well, how could Prop K have included provisions of the Sunshine Ordinance? Proposition K was enacted 10 years before the creation of the Sunshine Ordinance. Furthermore, the 3 attorneys have told you in writing that the Sunshine Ordinance does not prohibit an agency from raising its license fee to cover all of its administrative costs, including the costs associated with public records requests, so long as the individual requester is not charged for anything other than the cost of records duplication. I'll end if you wish.
Thank you. Okay. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Knebber.
While I disagree with the word jurisdiction, I've always agreed with the respondent's contention that this is that we can't regulate the fees they set to their members. I do think it's under our jurisdiction as a case, but I don't think that the merits allow us to find them in violation.
Member Snyder?
Yeah, I would agree with that. Ditto.
Member Johnson, Member Wolf?
A couple of things. It's a misrepresentation, no matter what you believe, to say that it says that the requester will not be charged a fee. Section 67.28, fees for duplication, A, says no fee shall be charged for making public records available for review, period. There's nothing about the requester. Prop K, it's true, was enacted prior to the Sunshine Ordinance task force, Sunshine Ordinance. And in addition, the Sunshine Ordinance, its purpose throughout is about having unfettered access to these documents, that there are documents as the public, not something that people get to keep from us. And in the record that we just watched, they indicate that it's for the Sunshine Ordinance, but they also indicate that they come to the legal conclusion that these are abusive Sunshine Ordinance requests. And it's not their job to decide whether they're abusive. We decide that here. But they took that on and explained to John Avalos that they were abusive. Maybe they believe they're abusive, but that's something that we're supposed to decide. That's just an automatic assumption. And I have a legislative opinion that was written that's based on statutory interpretation, and I have a number of legal cases. I'm not going to read them all, but this is legal research on statutory interpretation. And one of the first things it says is, the rules of statutory construction require us to ascertain the intent of the enacting legislative body so that we may adopt the construction that best effectuates the purpose of the law. And if we allow departments to start charging fees to openly walk up, because again, they say, can I address the street artist fee? They had already indicated all of the other administrative fees that were associated with their budget. And they specifically state, can I address the street artist fee? And they only refer to the Sunshine Ordinance. And that is not something that best effectuates the purpose of the Sunshine Ordinance. Every department could, and the very people who would need access to those documents might, you could reasonably assume it would be the artists. And so they're saying, every time you ask us for this, we're going to go before the board and circumvent the very purpose of the Sunshine Ordinance, which is to give them access to the documents, whether you're rich or poor, whether you can afford it or not. And the very purpose of that, and so they're enforcing it upon the street artists, the very people who would most likely need the documents. Now, I understand that that the attorneys, that wrote the Sunshine Ordinance have issued their opinion, but I think that there is some real valid reasoning for not just going along with that, because they are circumventing the idea that people should have access to these documents. The legislative opinion that was written, it's about electricity, but it's still about statutory interpretation, says the exact same thing. The primary task of statutory interpretation is to ascertain the legislative intent so as to effectuate the purpose of the law consistent with the language of the statute as a whole, to bring harmony to it as a whole. Otherwise, the purpose of not having a fee is negated. They're charging a fee anyway, and we're not finding necessarily, we're not going out and saying that the fee violates, we're not saying we're some sort of court or law that we can automatically say that particular fee that they approved is in violation. But if we find it in violation of the Sunshine Ordinance because of the charging them a fee, then at the very least we're giving the artists an opportunity to speak out about how they're having to pay.
Member Wolf?
That was very eloquent. I actually like that interpretation, and it's causing me to have some thoughts about this particular item. I'd like to ask Mr. Cancel some questions. Mr. Cancel? Oh, I'm sorry. Okay. Yes, absolutely.
Please approach the microphone, sir.
Sorry, what's your name again, sir?
Thank you. I'm Howard Lazar.
Lazar, that's
yes.
right. Okay. I'd like to know how many Sunshine requests your body, your committee, your department receives per year.
Okay, I can't speak for my whole department. I can only speak for my particular, I'm like a bureau in the department program. And unfortunately, I don't have that information with me today. I did a count of it last year. I believe it may have been about 10 or 12.
10 or 12.
I believe.
Okay.
I'm not going to swear on it, but the problem is that...
Okay, that's all I wanted to know this moment. Another question is how do you determine, based upon the testimony before the Board of Supervisors, before the Budget and Finance Committee, I think it was, how do you determine what is abusive and what is not abusive?
I didn't use that word.
Nobody used that word?
Yes, they did. It
they
says
did.
I didn't use
it's in
it.
the transcripts.
It's presumptuous of me to speak for someone else who's not here.
Well,
okay?
then,
are you not a knowledgeable person to be discussing it?
But I will address that question, though. Will address it in this way, that fulfilling the request was taking an inordinate amount of time of myself. I was one person. also charged by an ordinance of the voters to manage and enforce the street artist ordinance. And so when I came before you to your other committee, I said I don't want to be tardy in furnishing sunshine documents. I want to get this on time. I need help, and the way to get help is I need some outside help. And so we budgeted for that, as well as city attorney time. And if the city attorney is wrong in advising us, and by the way, the city attorney does not look at all the documents that we furnish to all of the cases, including one I was dealing with just yesterday.
Okay, thank you, Mr. Lazar.
You're welcome.
One of the concerns I have here about this, well, one is that, and I think maybe DCA 3 can answer this question with regards to the city attorney's responsibility to provide advice on sunshine matters to anyone in the city family that requests it. That information is supposed to be meant to be made available to everybody. It's not just necessarily specific. It's an opinion for all people, all members of the city family to have access to. Is that correct? Not correct?
Mr. Freed. Through the chair, Member Wolf, I'm not sure what you're asking me, so could you please repeat your question?
Yeah, my concern is when a department says that they have to pay for the city attorney for certain things, which they do, that is specific to the work that they do. But with regards to the Sunshine Ordinance, the ordinance specifies that no individual or department will be represented by the city attorney as like their defense counsel or what have you, and that the information or the opinions that are made are to be are global. They're not to be specific or like secretive, specific to that particular department. It's meant to be on behalf and in the interest of the whole. So my concern is if a department's saying that they're going to raise money to pay for attorney's time, city attorney's time, on which the city attorney has a requirement to make these opinions available for everybody, it just seems within their own budget to either they've already have made those opinions and are just making them available, or that they are making the question is being asked as part of a public statement from the requesting staffer for an opinion that's then available to everyone. I'm sorry if I'm not being that articulate about it, but we've been through this issue before.
Through the chair, there's a lot of layers to the question that you're asking, and I think you're making an assumption about what the city attorney is going to be doing in that role. Each department has a city attorney advising them, and when they get a public records or other sunshine ordinance matter that comes before them that's difficult for them to figure out for themselves, they may consult the city attorney and ask them for help. And it's a very fact-intensive look at the question. So, you may be creating a hypothetical that you would like me to answer, and if it is, maybe you can further illustrate that, because what you're asking me would cover the entire sunshine ordinance, and it could include things that are not opinions about whether a particular document is a public document, for instance.
Well, my concern is that when I was on the task force back in I think 2006 or so, we had DCA Zarefsky had come in to speak pretty much on behalf of a respondent. Actually, the respondent didn't really say all that much. There was like a defense that was being presented by DCA Zarefsky, and it was a lot of discussion around that item that it was inappropriate under the Sunshine Ordinance for any member of the city family who is a respondent to be represented by a city attorney counsel. And so it went further to say that the opinions, even written, if they are specific for the purpose of that particular staffer to represent themselves, if they were a written defense for them by the city attorney, that was also not allowed under the Sunshine Ordinance. And so my concern is when a department says that they are raising money or that they are using their money for legal counsel regarding Sunshine Ordinance, my concerns are that whatever product is produced from that is really for the benefit of the whole, not for that just one person. And that opinion must be made public for everyone to see. It's not for the benefit of just that one person or that one department. So it's not so much a hypothetical as it is an actual occurrence, and it actually exists in the Sunshine Ordinance.
Okay, I understand your concern.
Okay, so my question is whether it's appropriate for a body or a department to request the public to pay for additional funds for the city attorney to do this work when it's part of already existing work that they are already budgeted and being paid for to do.
What I think you're asking is an appropriate question, and I think that my answer would be that the appropriate venue to raise that issue would be before the Budget and Finance Committee of the Board of Supervisors and not this body.
Okay, very good. Thank you. Just a couple of more items, if you don't mind, Mr. Chair.
Wolf.
With regards to the Prop K issue, even though Prop K pre-exists before the Sunshine Ordinance, when a law specifies that a fee is to be spent on certain activities or certain items, that is why it's specified in the law. If it's going to be expanded in any which way, especially for something that is not in alignment with the current direct charge of that particular body, then the law would have to be amended to include that. And I think that's appropriate. And I think that we see that happen all the time. And for that matter, there are opportunities once a law passed by the voters is enacted and implemented, that there are opportunities for the Board of Supervisors to make certain adjustments. I don't know if this one is considered one of those adjustments, but it does have the ability to make certain adjustments, as we have found through our deliberations around the amendments for the Sunshine Ordinance, that there are things that have to go back to the voters and there are things that don't have to go back to the voters. So I'm a little suspect about whether the argument that Prop K existed before the Sunshine Ordinance and that this fee that they're asking for to pay for sunshine work is allowable under Prop K, or whether it's just inclusive of their current budgeting. Well, they don't get budget from the city, so maybe that's what needs to happen. They have to ask for special budgeting, specifically for the city, for a policy or regulation that is not part of their charge. That happens when laws are created and they're mandated locally. The local government can ask for reimbursement of certain fees or charges from the state law that's implemented. So I would think something like that could be done. I'm a little concerned that what we saw in the testimony and what's in the transcripts around why they're charging this, if they're only experiencing a dozen or so requests, and if they're that onerous, it's just part of the job. Just because it takes additional time, that's the way it is. I don't think there's any other department that has done it in this way or has asked for it so blatantly. They budget for it, and then when it comes budget time, they ask for more money. I do realize that this particular program or the Arts Commission under Prop K are not allowed to do that, but the Arts Commission does get money from the city. They have their own budget, and they could provide that money specifically for sunshine work over and above what the Prop K fees are supposed to be used for. Thank you.
Member Washburn, Member Johnson.
I've been looking at some of the documents we got late on and have some questions. This is one. This was an email, Chair Nee, that you sent to the attorneys who are experts in First Amendment and Sunshine Matters, and you're quoting a note in the Commission's proposed budgets, and you quote, for fiscal year 2010-11, to accommodate public records requests and investigation of street artist violations. The cost of part-time temporary help in the amount of $5,200, and city attorney's advice, $214 an hour times 65 hours, or $13,910 were added to the budget, end of quote. So it looks like this extra money that was being requested was not just to cover public records requests, but also investigation of street artist violations. I'm just wondering where this, so this was a note in the actual budget, I guess.
Well, the italicized part that you were reading is part of the original communique that I had sent to those attorneys.
Right, yeah, I was asking about where the quote came from. So it looks like it was a notation in the budget. I'm just trying to figure out the facts in the matter before us.
Mr. Chair, it does say in there a note from the Commission's proposed budget for street arts program. So I'm wondering, that's the reference I think she's referring to.
That's correct.
Yeah.
But their street artist fee specifically says it's. Unfortunately, in the last 2 years, we have seen a small number of individuals abusing the Sunshine Ordinance rules, requiring small groups to spend an inordinate amount of time responding to questions, responding to documents, etc. When they talk about the street artist fee, not the budget for the entire program, they did ask for investigations for the entire program, but when they talk about only the street artist fee, it is only to cover what they deem abusive Sunshine requests. They did ask for money in their budget about their program, but not the street artist fee. There's two separate things. And he specifically, once they finished going through the program budget, Mr. Cancel, or whatever his name is, specifically says, could I address the street artist fee? This that we just watched, it starts out. So the Sunshine Ordinance is only related to the fee they charge the street artists, not the entire budget program.
Okay.
Coming in here and changing it before us does not change what they asked the Board of Supervisors for. And it did not include, it's right here. I'm reading what he said to them. And they say it twice, 2 different meetings.
Okay. That's helpful.
Just that the budget, it is not the responsibility of people who ask for Sunshine requests to monitor the budget of a department. It's the responsibility of the people in the department and to monitor their own budget. And in fact, what I was going to say to Mr. Wolf is that we ourselves, as the Sunshine Ordinance Task Force, have been told that we have a limited budget to ask questions about the city attorney. We have to monitor our own budget as the Sunshine Task Force to ask Sunshine questions. Therefore, the other departments should also monitor their budget similarly, knowing that these are coming up.
Okay, that I'm just trying to understand the facts here, and they're a little bit confusing. The other thing, the other documents that we were given just here today, looks like it is true that Mr. Cancel has not taken ethics training or Sunshine training or any of that. It's documented here, And it looks like we could do a search and find out who has and who hasn't taken the training. Might be important for us to know. It could be that the people who don't show up don't understand their jobs very well.
A couple of comments I'd like to make. First of all, at the previous hearing 4 weeks ago, when the comments from the 3 FOI specialist attorneys were introduced, people on the complainant side suggested that I had not provided sufficient information to those attorneys, and they suggested that I supplement the information that I had provided. This I have done. Last Thursday, I sent a communique to all 3 of the attorneys who had responded, reminding them of the issue, repeating the initial communique that I had sent to them just to refresh their memories, and sending them the entire packet of information that had come before the task force. Within that packet, I referred those attorneys to the meat of the complainant's arguments. Since that time, I have got back one response. That was from David Green. And what he said is he has seen nothing in the additional information provided to make him change his mind. He is still of the opinion that there is no violation here. Second thing I will observe, regardless of whether the requests for information from the complainant to the respondents are abusive, the fact is that the respondents found that that within the staff and within the budget they had, they did not have sufficient time or resources to respond in timely fashion to the information requests that were coming from the complainants. And there is another way of looking at this, and that is by finding a way to increase their budget, to hire extra help. They are doing this so that they can respond to requests for information from the complainants or from any other member of the public in a more timely fashion than they have. Member Wolf.
My fear is that even if they are able to implement this fee, that there'll be...
The fee is implemented.
What?
The fee is implemented.
Okay. The fact that the fee is implemented, my fear is that there'll still be complaints. There'll still be problems. And that there may be what if there's an increase in requests? Then what? They're going to increase the fee again? I mean, it sets a really dangerous precedent for a responsibility that is contained in everybody's job description who takes a job here. And it's not about the commission or the program or the department that's supposed to follow Sunshine. It's about the people that are supposed to follow Sunshine. It's up to the individual. If one individual keeps getting hammered by Sunshine requests over and above everybody else in their department, does that create the right for that department to then increase its fee just for that one person to be able to accommodate that one person? It doesn't work that way. It's never worked that way. I don't agree with the fee at all. I don't know that there's actually a violation that we can actually point to, except that there is some reason to believe that if a fee needed to be charged, that the Sunshine Ordinance could be interpreted, the Sunshine Ordinance prohibits a fee to be charged to actually produce the documents, not to actually reproduce them for somebody who asks them, but to actually do the work to get to the point of actually being able to make a copy. Okay, so there's that, and I am, for me, I would want more debate and more deliberation on that item, and a little more investigation and questions with legal counsel on that item, because we're talking about something that sets precedent here. If it's not the will of this task force to find any violation, I would like to at least move that the Board of Supervisors be contacted, specifically the chair of the Budget and Finance Committee, requesting that these kinds of requests that be tagged onto any kind of fees be disallowed, and that if the city sees that there's an issue around cost for doing in implementing Sunshine Ordinance, that they find some more macro way of dealing with it to spread the wealth versus just accommodating one person. I think that there has to be some something that benefits all, and not just for one person or for one quote unquote department. Again, the Sunshine Ordinance is not geared for departments; it's geared for people. Thank you.
Further discussion? Is there a motion? Mr. Threed.
Chair, can you, I thought there seems to be a lot of concern about this, and I thought I'd offer two examples that might help understand the legal issue. And I think this example that's before the Commission is unusual because it's such a small program, and in some ways a specialized program, that the folks that are requesting the public records tend to be the same folks who are paying the fee. That is relatively unusual in the city. Permits, the city is allowed to charge fees for permits to those who try to obtain them, and it's allowed to recover all of its administrative costs in that fee. And if you look at an example like the Department of Building Inspection, for example, or the Planning Department, the folks who are obtaining those permits tend to be the building community and homeowners who are doing renovations. And the people who are requesting the public records tend to be a different population that is affected by that work. So if you look at that example, you can see that there's a real distinction. And it just happens to be that in this case, there's a large overlap in those two populations, but they're charged for different things. So I think that's why it makes it a difficult example.
Member Johnson.
I also just want to reiterate that I think this is 2404.11 that discusses the fees. I said this before. I just think that it's in violation of the findings and purpose, just in general, 67.1 of the Sunshine Ordinance, because it's meant to provide unfettered access to the public's documents without intimidation. But the fee, the section 2404.11 says that the fee collected shall be equal to, but shall not exceed, the fee necessary to support the costs of processing applications and examinations under the Street Artist Ordinance. There is no basis for the Board of Supervisors to have allowed them to increase the fee based solely on the Sunshine Ordinance. And it was especially egregious of Supervisor Avalos not to question, what do you consider abusive? And on the one hand, the Arts Commission comes in and says we're a two-person office. So he knows what they wanted, but when Member Wolf tried to ask, what do you consider abusive, he couldn't respond because the other person is not here. But they're only a two-person office, but he knows what is available. And I think that I'm just trying to point out that charging them for a fee is not consistent with the overall general reasoning of the reason why we have a Sunshine Ordinance.
Member Chan.
I just want to add it to Member Johnson. 12 is not abusive. 12 is not abusive.
Member Wolf.
If Member Johnson wants to make a motion, I would second it. to send a communique to the Board of Supervisors or to the Budget and Finance Committee. This is actually in the Sunshine Ordinance for us to, it's our charge to report to the Board of Supervisors from time to time, not just in an annual report, about how the Sunshine Ordinance is working, how it's being implemented, and the health of it with regards. And I think this is a perfect opportunity for them to review this kind of thing in the case that other departments decide that they want to use their fee for the same purposes. My additional concern is if there of the complaints or of the requests that are quote unquote not abusive, would there be any cause to raise the fee?
Is there a motion, first of all, is there a motion to find violation here? Seeing none, is there another motion that somebody would like to bring?
Can you find violation of 67.1, or do you have to go through and find the violation of everywhere where it says no fee?
Violation, whatever you want. As long as it
That would
applies.
be up to the maker of the motion.
Say that again, I'm sorry.
That would be up to the maker of the motion.
What? I think it violates the purpose. I mean, the one that I can find off the top of my head is that it violates 67.28A. No fee shall be charged for making public records available for review. So I'd like to find violation of that on 67.1 because it's a violation of the spirit of the finding and purpose of the Sunshine Ordinance Task Force.
Is that a motion?
Yes.
Is there a second?
I'll second it for the purpose of deliberation.
Okay. Discussion? Is there public comment on the motion?
Yes, I have public comment on the motion. It's very interesting, this game that is afoot here. A little while earlier when Mr. Wolf was talking to Mr. Treat here, which I believe is the city attorney, and was asking him basically whether, when a decision was ordered, whether it upgraded the entire system, and everybody knew in the city family of the determination or whatever order it was, so that it wouldn't have to be re-litigated later, because under litigation privilege, naturally the attorney can, by statutory interpretation, say anything that they want and have it be perceived as such. At that point, the city attorney, I believe, said to Mr. Wolf, well, you can go to Budget and Finance. And I think that was a disservice to Mr. Wolf, because the city attorney is supposed to be here to answer the questions of the Sunshine Commission, as opposed to the evasonary tactics that are used, along with the Ligitish legalese that they use in their speech to divert off the topics of what is at hand and what is present here. Unfortunately, this man in this one-person office, two-person office, whatever the case may be, my God is using a stone tablet and a chisel to push out this sunshine request stuff. We do not live in a modern age which we have computers we can scan stuff in and at the push of a button use any common sense or increase process. No, but we can certainly obscure everything and say, oh, well, I'm understaffed. We need to do all these other things, and therefore, I'm going to have the fee increased so that, I can comply with these things. Well, it's awfully funny because every agency has a fee, but, it's amazing how part of the mayor's department gets paid through the San Francisco Metropolitan Transit Authority's agency for special services that are done. It's amazing how this city family is interconnected with its finances and everything, but yet has a one-person place over there, like I said, Barney Rubble, on a chisel in stone to push out these big tablets, of requested material. Gentlemen, please, let's get back to reality and what this board should stand for. The citizens, the request for public information. This is a 20-year-old law. Jesus, probably 10 years ago they could have mimeographed stuff off and had copies in a filing cabinet they could have just mailed out. But now we're in a computerized era. I just do not understand the lack of logic nor the convenient little trail that the city attorney and everyone else is allowing you guys to be led down, and the lack of your all's logic in reviewing this.
Thank you. Further public comment, please.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. You really are in a position where the citizen is kind of caught between a rock and a hard place. It's like if I ask for this, they can choose to give it to me, and then they charge me a fee, and then they move the money around. The bottom line is, when you're a city employee, one of your job duties is to respond to sunshine requests. And it's their decision to say, oh, this is an additional duty, an extra duty, something that we have to have more money for. Now, bottom line is that they set the priorities. And if they put the sunshine requests at the very bottom of the list and say, oh, well, we have all these other things that are important, sunshine is not. So we're going to budget all the money we're actually getting, we're going to spend on these other things, and then we're going to consider sunshine requests to be something extraordinary. And therefore, we have to charge this additional fee. All that is saying is we're going to take sunshine and push it to the lowest level priority. And really, that puts the public in the position of saying, okay, now am I supposed to get involved in the city's priority as far as their budgeting requests? Trying to say to them, oh, complying with the law ought to be a little higher than investigating a street artist who might be committing a violation. It really does put the public in a position of saying, okay, gee, this is so much more complicated than I thought. The law is, I'm a city employee. It says, I am supposed to provide this information. It doesn't give them any outs to say, well, if you can afford to, or if you have the time, or whatever. It simply says you have to do this. And it's their choice throughout this entire argument to, from what I can see, put that sunshine request at the very bottom of their list and say the only way we can deal with this is by getting more money, and the only way we can get that more money is to charge more fees, even though the law says pretty clearly that we shouldn't be charging fees. And I think it's really how many angels can dance on the head of a pin to argue money's fungible. Wherever you spend the money, however you spend the money, it's spent. And making the argument that for some strange reason sunshine doesn't rise to the same level of importance as the other duties we have is exactly what I think they're arguing here.
Thank you. Further public comment, please.
Good evening, Commissioners. I just wanted to remind you, not too long ago, you had the billing department before you, and they were charging $6.50 for one photocopy, and they said the Board of Supervisors gave them permission to do so, and then you found that they were in violation and brought the cost back down to 10 cents. Just the same thing is happening here. Thank you.
Thank you. Further public comment, please.
Good afternoon, Peter Warfield. You usually hear me with respect to library matters, and I did not come particularly for this case, but there's some very troubling aspects of what's being said here, and I'm very glad that the motion was made as it was, and by Member Johnson, and I hope that you also inform the supervisors if you think that's appropriate. I've been urging this body to inform the supervisors on issues in a broader sense for some time, and I'm grateful for Member Wolf's suggestion. The Sunshine Ordinance does not define nor provide anything with respect to abusive or excessive requests. I don't see anything anywhere there. That's not to say people should put people to work unnecessarily, but there's no such thing, nor is there even certainly any method for determining any such thing. The so-called abusive requests and other such spanking of requesters, in my experience, typically comes from departments who have something to hide or who want to withhold something, often in violation of the law. That's been my experience. it's very easy to go around saying, oh, these people are driving us nuts, they're making unreasonable requests. I even heard that in one instance that I was involved with, the word was out that there was some terrible thing because the requester wasn't coming promptly enough to pick up the materials, and what a terrible burden that was to have it sit on a desk for more than a few days because this was such a terrible... Again, the idea that you could specifically increase a fee or any other charge because some bad people are busting our chops with unreasonable requests or other words like that is an invitation for abuse on the part of the government agency. It would encourage, if you went along with it, everybody who wants to obstruct, to do what one of the former speakers says, put it out on stone tablets, or in some other more sophisticated way, do it like, we got to consult the city attorney, we have to have a meeting with the city attorney, to basically to balloon their costs, which ultimately very well might be obstructionist costs. So I think that the specific purpose of this increase on a particular group and calling it a fee was to spank the requesters in front of their peer group, and that's it. Now, I do understand that the respondent may have a legitimate concern about what could be viewed as an unfunded mandate. And that's another problem altogether that needs perhaps some kind of discussion. But there's all kinds of unfunded mandates. Daylight savings changes on a new date. A new law is passed. These have to be absorbed all the time. And if there is an added expense, then people work it out in some other way, but they don't spank the requesters by calling their requests names.
Sir, your 3 minutes has expired. Could you wrap it up, please?
Okay. So I'm concerned about the potential for abuse on the part of the agency in doing what they appear to have done, and I support the motion very strongly. Also would ask their evidence for these supposed abuses, and I don't think it's been presented.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. The matter is back with the task force.
Chair.
Member Wolf.
I just want to say with regards to the Sunshine Ordinance not speaking to what is described as a request to be abusive or what have you, 6735C does speak to a court determining that a request could be considered frivolous. So there is something in the ordinance that does talk about that. I'm a little torn as to whether I'm going to support this motion or not, even though I seconded it. But I'm very much more interested in sending communications to the Board of Supervisors under 6730C, which basically is a charge for us to make these reports when we find that there are any practical or policy problems encountered in the administration of the Sunshine Ordinance. It's in black and white. It's in the ordinance. And I think it's within our ability to do that, and I think it's appropriate.
Before we proceed further, this is a lapse on the chair's part, and I apologize for it. Procedural lapse. The respondent and then the complainant are each to have 3 minutes to make any concluding or rebutting remarks. Mr. Lazar.
All I can say is you've heard from the experts, you heard from the author of the 1993 Sunshine Ordinance. You yourself, Mr. Nee, talked about one of the attorneys still saying he hasn't changed his opinion. You hear from your city attorney. I mean, I go to the horse's mouth. If the author of a piece of legislation is still alive and can be asked an opinion, and he gives his opinion, I would be highly presumptuous to overrule his opinion. I mean, it doesn't make sense. I knew, for example, Bill Clark here was the author in 1974 of a street artist ordinance, Proposition J. And years later, I would come to him and ask him, even after J later vanished, I would ask him about intent, purpose, and all that. And he was forthright with his answers, and I accepted them. I knew he was right because he was the author of the ordinance. Why would I ever question that? And so I'm asking you that question. Why would you even question the author of the ordinance? Thank you.
Thank you. Mr. Clerk?
Real fast, just to let you know, the court has already ruled, even though my brother is an author of Proposition J, it's the words in the ordinance itself that has to be looked at. And even if the author meant something differently, the court will rule on what the words of the ordinance is. The chairman, you made the statement about Mr. Lazar saying that he's a small staff, and therefore they were just requesting more help to help with the Sunshine Ordinance request. I mentioned to this board earlier last month that since January, last January, we have not had a second full-time employee. So first of all, there is no need for them to request a third temporary employee to help them with sunshine ordinances until they hire the second full-time employee, which we've been paying for since January. I want to make it clear that Mr. Lazar came in here just a few minutes ago and said that he hadn't heard about this $30,000 surplus until recently. Well, I believe this is in your files, but this is December 16th, 2009, when the controller informed the accountant and Mr. Lazar that this $30,000 surplus was in the funds and was available. And just recently, that recent email that we sent to you was from Mr. Levinson telling Mr. Kinsell that there was more than enough money in our funds at the end of the year, and he even requested Mr. Kinsell to withdraw the fee increase, that there was enough money in those funds to pay for any of the stuff that they are requesting. Mr. Kinsell refused to withdraw this fee increase. And to the gentleman here, I want to remind you that we came in here, we made it clear, there's no doubt they have the authority to raise the fee. But Proposition K makes it clear in the ordinance that only when necessary they have the authority to raise the fee. And since the controller made them aware of the fact they had more than enough money to pay for their services that they were claiming that they need without raising the fees, they decided they were going to raise the fee anyway. And they only were doing that to intimidate us, to stop us from asking for legitimate requests under the Sunshine Ordinance, because we do have a very important financial problem that we're trying to deal with. So even though the distinguished lawyers that are experts in the Sunshine Ordinance made it clear that the authorities have the right to raise the fee, they're not experts in these other aspects of the law, and there is no doubt that Proposition K does not give them the authority to raise the fee unless necessary. It wasn't necessary. And if you allow this, if you don't vote in favor of this lady's motion, you are in effect amending the Sunshine. You are allowing the Board of Supervisors to illegally amend the Sunshine Ordinance by allowing them to charge us a fee for Sunshine Ordinance requests. It is an illegal amendment of the Sunshine Ordinance.
Thank you, Mr. Clark. Matter is back with the task force. Member Johnson.
To address two things in defense of my motion. Number one is this Sunshine Ordinance Task Force has spent the last year trying to revise the Sunshine Ordinance. So just the fact that the author authored it was unprecedented. And we are learning as we go along. And it's already been revised once by Prop G in 1999, something that was really not in there. And not only did we spend the last year trying to revise it to shore up these loopholes, there have been many personal arguments and a lot of strife that's come from those arguments. So the author did an excellent job, and their contributions are excellent, but they're not here day in and day out to hear how people try to circumvent it and to hear the loopholes. That is why I'm questioning the author's opinion. Secondly, the reason why I don't only want to send it to the Board of Supervisors is because we also had a conversation during budget about the hostility that Supervisor Ellsburn and Supervisor Maxwell were showing to the Sunshine Ordinance Task Force, and they were threatening about our own budget. So I don't want to just leave it up to them because it's another one of those things that they'll just leave sit there. That's just the reason why I only don't want to go with that, or I'm reluctant to only go with that.
Member Wolf?
The only thing I would say is regards to Prop K and the Sunshine Ordinance, that 6736 is very specific with regards to the Sunshine Ordinance in regards to other local laws. Prop K is a local law. That the provision of the Sunshine Ordinance supersedes other local laws. Whenever there's a conflict in local laws identified, the requirement which would result in a greater or more expedited public access to public information shall apply. I mean, we're not dealing necessarily, I mean, I think there is some question around that there is some conflict here. Obviously, we're in a kind of an judiciary kind of situation here. So I tend to, when I make my opinions about Sunshine Ordinance regarding this, I look to 6736 because that's the crux of why I'm here, is to give more sunshine to the people. That's what's important to me, and if you go back to 67.1C, 67.1C talks about the evolution of government and how laws need to evolve over time. It states, all government evolves, so must the laws designed to ensure that the process remains viable. And so we're dealing with exactly that. We're dealing with a program, a department, people that have come to a state of evolution. They are growing. The public is asking for more information. Things are evolving. So must the laws, and so must the regulations. And I think at this point, I am going to vote in favor of this, but I'm also going to, I want to, if I can, make an amendment to under 6730C to send a report to the chair of the Budget and Finance Committee of our concerns about that of just how departments are seeking ways to pay for a job that is already contained in their job description, and that if it's considered to be an unfunded mandate for specific departments, that they seek to reimburse them for that time, and not it be a burden on the people of the city and county of San Francisco. We are already paying for it as taxpayers.
It's double dipping.
Does the chair accept the amendment?
Yes. I mean, the maker of the motion.
Yes,
Second.
does the maker of the motion. Well, the second proposed the amendment. Does the maker of the motion accept the amendment?
Yes.
Okay. Member Washburn.
I don't know when to bring this up or if it's appropriate now or later, but the fact still remains that one of the employees has not taken the training, the ethics training, or the sunshine training. And I think this could be a systemic problem that we should investigate and report to the Board of Supervisors or the Ethics Commission. I don't know. Ethics, probably. I just don't want to lose this
Do you wish
possible problem.
Do you wish to make an amendment to the motion?
I don't know if that's appropriate.
Okay.
So
Could you, Member Wolf, could you repeat, please, the amendment you've made to send
Yes.
a memo to the Board of Supervisors, Budget and Finance Chair?
Budget and Finance Chair under 6730C.
Right.
Okay, that that the concern of the Sunshine Ordinance Task Force that departments may be seeking fees to or increases or adjustments in fees to pay for their responsibilities under Sunshine that is already contained in each individual's job description.
Okay. Further discussion.
And that they should, if there are unfunded mandates for programs and departments like the one we're seeing here, where they get no city funding, that they be reimbursed for this requirement, and it not be on the people.
Member Johnson.
Just to add to that, you hear similar discussion when we talk about electricity rates and how the investor-owned utilities are able to ask for rates that certain things are already included, so they can't double dip. So if we're saying in the Sunshine Ordinance that it's part of their job, asking for additional money on top of that is like double dipping from the public. And considering what Mr. Threet said, that it is unusual that in this particular circumstance, the people who would most likely ask about these documents are the artists themselves, and they're imposing this upon them.
The chair is going to request a separation of the amendment from the main body of the motion. The reason for that is that I think the amendment's a good idea. The amended portion is a good idea. However, I do intend to vote against the main motion. Is there? The chair will move for separation. Is there a second?
Second.
Moved and seconded. Discussion. Member Johnson.
I think that I just want to say it. I think that you're doing, and with all due respect, you're doing a disservice to the people who come here before us by only sending it to the Board of Supervisors. It has been before them before. They accepted it, and I don't think that Budget Chair Avalos is going to give it any real consideration, the same consideration that we give it here. And I just want to put that on the record because you're separating out something that would be significant that they would have to pay attention to something they can just walk away from.
Is there public comment on the motion to separate?
Yes, thank you. I'm here again. Unfortunately, I believe what Ms. Hope Johnson was saying is absolutely correct, that, this is all together one bowl of wax. It's not based on how you might see it, what the attorneys might say, what the evolving law might mean. When any of this, your duty is to the citizen and for them to get what's requested. All this other stuff is red herrings. It's, policy, it's procedure. It's not dipping in this fund. It's robbing Paul to pay Peter. It's all this false, fake process. It's very, very, very simple. This statue has been here for years, and for years the city family has found a way and the loopholes to get around it. They're doing it again because our wonderful chair will do what he's allowed to do, by a process that's set up to fail. So congratulations and welcome to the real world.
Thank you. Further public comment on the motion to separate?
Task Force members, Ray Hartz, Director, San Francisco Open Government. I have to give a kudo to Member Johnson for her statements in the fact, yes, it really is just kind of egregious that people come here and they're dealing with representatives from the city agency, none of whom I think would ever deny that they are professionals. And yet they will come in and they will act totally unprofessionally in the process. They will send representatives who don't know what the issues are. They will send people who can't respond to your questions. They will send people who make specious and outrageous arguments sometimes. Or they'll send people who, in one of the cases you looked at earlier, I want a continuance, but I'm not going to tell you why I want a continuance. I just want a continuance. So it's just one thing after another, and members of the public are the ones who end up bearing the burden in each and every case. If they don't show up, continue it. If they don't show up again, continue it. If they don't send a letter, continue it. And like the one case that was here before was, okay, now the election's here, and it's too late for us to do anything. And it really becomes a self-fulfilling prophecy. And as the previous speaker said, the city agencies have gotten very, very good at learning the ways that they can maneuver themselves out of answering for this. One of the basic ways is going before ethics. You have to be a managerial person. In other words, you have to be somebody in a position of responsibility. Well, if you attend your hearings, and you all do, obviously, you notice that they'll never send anybody in a managerial position. They only send the peons, because none of them can be held liable for failure under the ethics law. That's the coffin issue. It's basically, this is not a city employee, and this is not a person who is a managerial city employee. Therefore, you can't find her liable, even though she is. And at some point, you're going to have to say, what is this law limited to, but what are we able to do with it? And the argument that somebody, when they initially wrote the law, intended it to be one thing, it goes back to that question. The law is an evolving issue. As the city learns ways to get around this law, this task force has to find ways of saying, no, you can't. It's like employees who are constantly coming up with excuses as to why they can't do something, and after a while, you don't have help, I'll give you some help. You don't have some advice, I'll give you some advice. You don't have this, I'll give you this. And you close the doors until the only way they have is to go to the place we want them to go, which is to obey the law or do the job. And that's what they need to be told. This is your job. Whether you agree with it, whether you like it, whether you feel it's fair or not, it's your job. Do it.
Thank you. Is there further public comment on the motion to separate?
Commissioners, I can only hope that you believe in Hope Johnson and support her and stop doing injustice to the people. Thank you.
Thank you. Is there further public comment on the motion to separate?
Thank you, Mr. Chair. Peter Warfield again. With respect to the question of fees, it's my understanding that fees are supposed to cover the immediate cost of the specific action or service that is provided, and not to cover variable things that may or may not be involved with handling the specific matter that is before for which the fee is being collected. On the splitting of the question, I would hope that members of this body would ask the chair perhaps strategic question, and that is whether the failure to, whatever you call it, split the motion would make the chair vote against the combined motion. If that were the case, I would hope you'd consider strategically that at least something is better than nothing, and it might be better to split it. If, on the other hand, he says he'll vote for the combined motion, if you don't split it, that's another thing to consider. So it seems to me pretty much up to the body as to what you want to do about splitting the question, but I do think that you might have a little bit of further discussion to clarify what the effect would be of doing or not doing that. Thank you.
Thank you. Is there further public comment on the question of splitting the motion? Seeing none, public comment is closed. Is there discussion? Roll call, please, on the question of whether to separate the items in the motion.
On that motion, Member Snyder?
Yes.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Aye. Knebber, aye. Member Wolf? No. Wolf, no. Member Chan? No. Chan, no. Member Member Johnson?
No.
Johnson, no. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 4 ayes and 3 noes.
Okay, because this is procedural, simple majority can prevail. Therefore, the chair will rule that the items can be taken separately. Let us take first the the main motion then, and that is whether to find violations of 67.1 and 67.28A. Roll call. Is there further discussion on that motion? Seeing none, roll call, please.
On that motion, Member Snyder?
No.
Snyder, no. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
No.
Knebber, no. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
No.
Nee, no. Mr. Chair, we have 4 ayes and 3 noes.
The motion fails. Now, can we take the second part of the motion, please, on whether to refer the matter to the Board of Supervisors?
On that motion, Member Snyder?
Yes.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
No.
Johnson, no. Member Nee?
Aye.
Yeah, Mr. Chair, we have 6 ayes and 1 nose.
Motion passes. That concludes this item. We'd like to thank both sides for attending and for your input. We'd like to thank all of you here for your patience. We know this is a long process. At this time, we are going to take public comment, general public comment on items not on today's agenda. And when we're done with that, we're going to take a brief recess. Sir, thank you for coming. You have 3 minutes.
Yes. Unfortunately, I have a matter in front of the task force that when I spoke to Mr. Rustum about, sent me a email that was quite cryptic to me. According to this email, my item was tabled, so I'm a little confused as to where my item stands, and what it all means, and how this process has so far been thwarted for an IDR that was supposed to have been received within 24 hours, and it's now been 5 months. So this is the nature of my complaint that I've been up and telling you about how false your process doesn't work. Now I've received this email. In this email, it also says that the complainant was not present. I would like to remind the chair that the chair asked me to leave the meeting. And I'd also like to remind the chair that the 2 prior times that I had been here and submitted evidence to which I was duly asked to respond by all the members, the evidence was submitted. I would also like to tell the chair that there's a 40-day allowance in which to respond promptly to this, and it's now been 5 months. So I am very confused as to where my matter stands with this body, which doesn't apparently seem to follow its own bylaws. Please let me know so as I can proceed appropriately.
Okay, sir. You have not identified yourself, and I think in this case it would be appropriate that you do so.
My name is Jason Grant Garza. My case number was 10038.
Thank you. Ordinarily, we do not respond to items of general public comment. However, in this case, I think it is appropriate that we do so. First of all, Mr. Garza, you were asked to leave the room because you were making gratuitous comments out loud, and your conduct was, in fact, hampering the progress of the meeting we were conducting at that time.
Thank you for your allegation.
This was, I believe, at our last regular meeting.
Thank you for your
had the
allegation.
option. You had the option, sir, of remaining outside and coming back.
I was
in the
not
room.
told that, sir.
Okay.
So thank you for that allegation.
You could have done that. Now,
I don't believe so, sir. I was told that I had to leave or I'd be escorted out by security. I
Okay,
was
you
not
could've-
told, sir, and I'm sure we could replay the minutes, that I could wait outside. So that representation that you are making is misrepresentational and deceitful.
well, you are correct, sir. You are correct in stating that we did not advise you could remain outside, and that is.
Now, let's not forget that I've been in front of this commission.
Okay, sir, please let me finish.
Please.
Should you wish to have this matter brought back to the back before the task force, the matter has not been concluded, and we can bring it back. We could not do it tonight, but we could bring it. We could place it on the agenda for our next regular meeting, which would be November 30th. Do you wish to have that done?
I'm not understanding of that question.
Do you wish to have the item brought back for our next regular meeting?
When you say brought back, what does that mean?
Placed on the agenda
current? Do you pick it up where it was left off and tabled? Do I have to refile the thing for a reconsideration after having been delayed for 5 months?
No, sir.
Will you respond to the 40 days that you did not properly issue an order of determination and violate your own bylaws?
Okay,
what does this all mean, sir?
Sir, you would not have to refile anything. The matter would resume where we left off the last time.
And would that also mean that the people who failed to be the respondents that weren't here and the complaint that you pushed up to Ethics Commission would have been decided by then, and we would see the lack of punishment and how this entire thing is a farce? Yes, I would like for this matter to be reconsidered appropriately. I would also like for all the questions that I've asked all along and all the evidence that I've submitted all along on this case and this merits for the denial and the delay in this process. You have harmed me, sir.
Okay. Sir, Mr. Garza, first of all, in terms of where procedurally we were with your matter, I would have to go back and review that with the clerk's assistance so that we can make sure that when this comes before us next month, we can pick it up in the appropriate place and take whatever appropriate action is necessary.
And do you also acknowledge that it's going to be 6 months then at that point for having made a decision on an IDR which should have been filled within 24 hours? Do you also realize that the fault of your procedure has further harmed me, sir?
Sir, you're... I will not answer that question, sir.
Naturally. Yes, I want proper process. Please provide it, as I have sought it all along. And if that involves this, per Rogers' parliamentary procedures, being picked up off the table, which is, of course, naturally something that should have been done at the end of the last meeting as opposed to me having to bring it up according to parliamentary procedure, but naturally, since you people don't have to follow your own laws, it is not my ethical problem, it is yours. So yes, let us continue to do the right thing in an unright system where no right consequence comes of it.
Okay, the chair will instruct that this matter be brought back at our next regular meeting. Thank you. Is there any further general public comment?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I think this task force really is at a point where I see a real strong division showing out of people who are very restrictive in their view as what you can do with this law and what you're entitled to do and so forth, and another camp that's basically looking at it more positively and more in the line of what I would look at, which is what are we able to do with this? Whether or not you can legally penalize someone is not always the objective. It's whether you are willing to use your moral suasion to move it forward. In reviewing the reports from this committee or this task force to the Board of Supervisors over the last number of years, I think there's been a lot of confusion of activity with accomplishment. You have been very active in that you've heard a lot of cases and you've made a lot of efforts to change the law and stuff like that, but what has actually been accomplished? Are the citizens of the city and county of San Francisco better in their ability to gain access to public records and better off in their ability to make public comment, or are they not? And while you've had a lot of activities and made a lot of decisions, I don't really see a lot of improvement in the general ability of members of the public to enter into the public dialogue with any degree of confidence. Why? Because when they come here, they have to be lawyers. They have to then present a case against the city attorney, against the agency's city attorney, or whatever other attorneys they have. You've got all these legal experts coming in, and you basically have this one person that says, look, all I'm asking for is a public record. Something that you know damn well I'm entitled to have. Take my case against the Rent Stabilization Arbitration Board. I'm dealing directly with the executive director of that body, and it took me 6 months to get stuff which they knew the entire length of that time I was entitled to from the very day one. Like I said before, you're dealing with professionals who, for their own convenience, will just pretend like they're dumber than a box of rocks. Is the front page of the application disclosable? Yes. Well, what about the back of the same page? No. And that's what they did to me. They gave me the front of one page and withheld the back. And then subsequently, 6 months later, gave me the back of the page. And they want you to say simply, oh, well, you gave it to them. It may have been at the very last minute. It may have been on the very day of the hearing, whether they would have been fined in violation. And then after they agreed and I said, fine, okay, fine, I'm willing to say the complaint satisfied, you get up and say, oh, well, what Mr. Hart said is wrong. It isn't we knew it was there and we withheld it. That's not true. I'm dealing with somebody who's an executive director, another person who's an attorney, and I don't think it's very credible for either of those people to say they can look at a document and not know from the beginning it was responsive.
Thank you. Is there further general public comment?
Good evening again, Task Force. My name is Peter Witt. I have been here before several times in the over the last decade. With reference to case 08053, file 2209, I never received a response on that complaint, or with the additional evidence, supporting evidence rather, that was needed in that case, Exhibit A through I, at the request of the order of determination that was determined 1/2709, and is now included, as I included, currently I just sent you an email today, Exhibit J and Exhibit I was revised. So I understand there might have been a little confusion because I filed a complaint with this task force on 2409. Which actually was very critical of this commission and or body. And you advised me, I was advised that I should take that complaint to the Ethics Commission, and I have yet to do so. Yet I am considering it. So, but today I'm here to reintroduce that complaint, the 2209 complaint. Exhibits A through I emailed you at that time. And I also would like to bring a new complaint. I just filed today, via email against the MTA, misleading the public through the minutes, misrepresenting the public through the minutes, and a failure to include public correspondence in the PC&N process, and finally omitting 150-word statements that I wanted to have included into the minutes. And a few other complaints I have. I can finalize those by next month. So hopefully we can notify the proper parties for their violations. So, you know, I'm not here. I don't speak professionally. I'm just a citizen. Grew up here in San Francisco. But I'm very much concerned about the functions of government and the working system that is not working in many facets of, I believe, in our government as a whole, nationwide. And I believe the small peon, the smallest part of our systems are failing. And that's right here at home, in our hometown, or anybody's hometown. And I believe that it transgresses to the higher-ups. Maybe Bush, Cheney might have something to do with that. Yeah. I don't know where they get their information from, and I don't know where you get your information from. So thank you very much.
Thank you. Is there further general public comment?
Thank you. Peter Warfield, Library Users Association. Couple of points from observation here. Section 67.35 enforcement provisions says that if a court finds that an action filed pursuant to this section is frivolous, the city and county may assert its rights to be paid its reasonable attorney's fees and costs. So I think that determination is up to the court in the case that a court enforcement is attempted. Just to clarify on facts. Second, with respect to the first public commenter, it is certainly okay for the members of the task force to respond, or anybody to respond briefly to a public comment. There's no requirement not to. And I know that that's not what the chair said, but I certainly hope that everybody understands, because we have found in other places that the claim that there's no requirement to respond is used to hammer other members of a commission into not asking further questions or responding even briefly, which is explicitly allowed under Sunshine. I'm disappointed to hear some of that exchange, and am concerned. I'm certainly glad that the chair plans to put that item back onto the agenda. I think that another speaker talked about what progress have you made for the public, and I think that would be a very good project for a report and some research on your part. I have many times suggested, mostly in connection with amendments, that you solicit people who have in various ways been using the Sunshine Ordinance or had involvement with it. For example, people who have filed complaints, people who haven't filed complaints, people who have filed complaints that were and were not successful, to find out from them how it has been working. I think that would be very excellent for you to do. Finally, I'm a little bit concerned about what I understand and take in good faith to be an effort on the part of the chair to be resourceful and to add information to cases. Well, let me just say, this book does not have apparently a complete file on the case that was just taken up. There were many references to correspondence and whatnot that were simply not included here, and that's a big disappointment when you do have a public review file. The going out to particular sources for an opinion, I think, is very problematic. The first question is, who do you go to? Why don't you go to solicit the opinion of the Sunshine Posse, people who have come to you previously, maybe people like myself who've won a unanimous decision, even though the city attorney advised the department that they were right. So there's a range of questions as to who do you ask and what information is provided and how public that is. And I think that's potentially very problematic and should be dealt with in a very cautious way.
Thank you. Is there further general public comment? Seeing none, we are on recess for 5 minutes.
We're back in session. A matter has come up that prompts the chair to ask for a possible reconsideration on agenda change. This would involve moving items 12 and 13 up immediately. The reason being that we would have one recusal on this item, and we have another member who needs to leave shortly, and if items 12 and 13 are not heard right now, we lose the quorum on those particular items. So if there is no serious objection from the complainants or respondents in items 9, 10, and 9 and 10 and 11, Mr. Tilden, representatives from the Recreation and Park Department, Ms. Chang, representatives from the Planning Department. Are there any serious objections to moving items 12 and 13? Those are actually a united item. Are there any serious objections to moving those items up to be heard right now, sir?
No objection. Just a question.
Sir.
If we lose the quorum, will our items still be heard without a quorum?
No. The thing is, we would not lose a quorum for your item, but we have one recusal for items 12 and 13.
Different type of a quorum.
Different type of a quorum.
Thank you.
Yeah. We lose in effect, two members. Sir?
I have one question because I have two matters regarding the police commission, and normally Member Chan recuses himself, which means I'd be in the same kind of position. It won't? Oh, okay.
I have appointment at 8. How soon my case will be heard?
I would estimate in half hour, 45 minutes.
I guess, okay.
Okay.
I really have to, very important appointment.
Thank you. In that case, we will hear items 12 and 13.
Chair.
Member Chan?
Because I have to leave soon, and the most I could stretch is 7:30.
Okay. Well, but we still need you here. If you're gone and Mr. Wolf is gone both, then we lose the quorum anyway. But at least this gives us a chance to hear at least one set of items. Member Wolf indicated to me he had to go about now, although he is willing to remain for items 12 and 13 if we wish. Sir.
Yeah, Brian Smith from the Planning Department. I would really respectfully object to changing the Planning Department's item number for a later time. I need to be getting to kids myself, and our matter was also taken off of the last meeting as well. Prior to my knowledge, I sat here for an hour before someone told me that Ms. Stang had taken it off the previous meeting.
Understand. How soon do you need to leave, sir?
No later than 7:15.
All right.
I needed to clarify his misstatement. Last scheduling hearing, he wasn't present at all. And then he says 1 minute before the hearing, to be exact, 3:59, he emailed free email to Rostam. He handed to me. That was the continuous. He wasn't even appear. Yes, last hearing. Now she's complaining about, for some reason I wasn't there or whatever. Why was here?
Okay, thank you.
I really needed
Thank you.
to. Okay.
Chair is going to rule for items 12 and 13 now. Mr. Clerk, could you call out item 12, please?
Yes, Mr. Chair. Item number 12 is determination of jurisdiction on complaint filed by Kelly Lanza against the District Attorney's Office for allegedly not responding to her public records request.
Is there a motion to find jurisdiction?
I move that we find jurisdiction.
Is there a second?
I second.
Moved and seconded. Discussion.
Should I recuse myself right now, or do I
Okay.
have a motion to recuse myself?
Okay, a motion to recuse on these items is necessary. Member Chan has requested to recuse. Is there a motion to recuse? Moved. Is there a second?
I second.
Moved and seconded. Because this is a procedural item, the chair will not take public comment on this item. Roll call, please.
On the recusal, Member Snyder.
Aye.
Snyder, aye. Member Washburn.
Aye.
Washburn, aye. Member Kneba. Kneba, aye. Member Wolf. Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Yeah, Mr. Chair, we have 6 ayes.
Thank you. On the motion to on the motion to find jurisdiction to this item, is there any public comment? Seeing none, public comment is closed. Further discussion? Roll call, please.
On jurisdiction, Member Snyder.
Aye.
Snyder, aye. Member Washburn.
Aye.
Washburn, aye. Member Kneba. Kneba, aye. Member Wolf.
Aye.
Wolf, aye. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 6 ayes.
That takes us to the merits of the complaint. Ms. Lanza, thank you for coming. You have 5 minutes.
Thank you. I'll keep this brief. I think that the facts of it speak to itself. On June 29th, 2010, I placed a request of the District Attorney's Office to comply with a number of public records or questions for public records. I received a response from them on July 12th, or dated July 12th, saying that they needed 2 extra weeks. I had no problem with that. I waited those few extra weeks, and then I gave them a little additional time. I understand that sometimes these requests take time. Around mid-August, I started about once a week giving them a call, and then the last week of August, I sent an email asking for a response. Never heard anything. Sent them a demand letter September 2nd, which was also the day that I filed a complaint with the task force. I received a response from them on September 7th saying that they had a few items available to me, and they sent me 69 pages, which were basically the office budgets and the names of the employees of their office, which were 2 of my questions, 2 of 11 questions. I didn't think that that was adequate. We had our first hearing. They said they couldn't come. I don't know. Now, last week, they gave me a response to question 3, but it was half of a response. I requested travel and reimbursements. They gave me travel, not reimbursements, but that's beside the point. So now it's been 4 months, and I've received answers to 3 of my 11 questions to their office, and then they don't show up tonight. This is my only real recourse in this, is filing a complaint with the task force, so I'm just asking that whatever needs to be done to get them to comply or to, I don't know, slap their wrists or tell them to fulfill their requests, that's all I'm looking for.
Thank you.
That's it. Thank you.
Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present, please? Thank you for coming, sir. You have 5 minutes.
As I said earlier, my name is Seth Stewart. I'm an assistant district attorney here in the city and county of San Francisco. I am not at all familiar with the requests, and I was asked to be here to request a continuance in this case, given the facts that the people that are familiar with this particular request are unavailable. I did have a chance to speak briefly with somebody from my office during the break. I do believe that Paul Henderson had some type of dental work done at the same time of this meeting. I think he's trying to make it over here. I don't know if he'll make it here in my 5 minutes. Mr. Henderson.
I just got surgery. Sorry.
Thank you. Please give him a full 5. Please proceed, Mr. Henderson.
We are having an opportunity to respond to this is our 5 minutes.
My understanding is we have been addressing the requests that have been coming into the office as they have been coming in. I'm sorry, I just had dental surgery. They wouldn't let me leave until I waited 2 hours because of the medication. As soon as I left there, I came directly here.
Thank you.
That's why I'm speaking funny.
Please proceed.
Okay.
We'll be as patient as we can.
So I think I know most of you by now. I'm Paul Henderson. I'm the Chief of Administration at the DA's office. My staff, who has been working on these issues for these specific requests has been working on these requests for a long period of time, and we've been getting them the stuff as we've been making them available. But as you know, many of the requests are quite voluminous, the things that they've been asking for. I don't believe we've asked for a continuance ever before with these issues. I know as recently as last week I just signed something turning over more of the documents. In fact, I think it was this week I turned more documents of things that they had asked for. We just need a little bit more time. We're happy to comply with whatever time requirements we all see fit, but my understanding from my staff is that we're not done yet. I wish I had more. That's the only information that I have.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, Mr. Henderson.
I'm sorry, let me explain more. My staff that normally works on these projects, part of the reason that we asked for the continuance is because none of them are available.
Mm-hmm.
And they couldn't be here today. Otherwise, I could tell you the specifics of what's taking a long amount of time and why, in terms of where the documents are, how they need to be created or put together. But in terms of speaking in support of what I've said, my staff that typically works on those things cannot be here today. That's the main part of the problem. And obviously I couldn't either, but whatever you got me here, and I've got
okay. Well, we want to thank.
That I won't take until after we figure out what we're going to do.
Okay, we want to thank you for coming over here from your surgery. We certainly hope you're not in too much discomfort.
Not yet. Not yet.
Okay. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Member Wolf.
Just reading this through, I just have some questions to DCA 3 on the applicable case law. Was that something that you provided, or was that something that was provided by the respondent?
Through the chair to Member Wolf, if the respondent did cite to those cases, which are the standard cases in this area for the rule of reason, in responding to the complainant, and they are also in the memorandum that I provided to you.
Right, which is what I'm reading from. My next question is in response to Bruce versus Gregory, dated 1967, which was a case prior to the formation of Public Records Act. Is that correct? It says we such and such hold that rights created by, and then in brackets it says predecessor statutes to the Public Records Act.
That is correct, Member Wolf. Prior to the enactment of the Public Records Act, there were other more specific statutes that address certain agencies in the government.
Does the implied rule of reason apply now that the Public Records Act is in effect?
Well, Rosenthal versus Hansen, which is the 1973 case, extended that rule of reason to the Public Records Act.
Okay. And my last question is in the citing of Bruce and Gregory, it mentions a custodian of public records. Is that the same definition as what is contained in the Sunshine Ordinance?
I'm not prepared to answer that question. I don't know. That's a very specific question.
Well, my concern here on this case, needing some guidance, because I'm not sure whether the district attorney's office is citing a case that actually applies to the Sunshine Ordinance. If it describes a custodian of public records in a different venue under a different statute of law, and not under this one, and the description in the definitions of the law is different, then I don't see how this case would apply.
Well, I think it's an open question whether it applies to the Sunshine Ordinance. The extension of the rule of reason to the Public Records Act was based on the effect that a onerous request might have on the agency's ordinary non-public records duties, and whether it could still perform those duties and adequately and respond in a timely manner to the public records request. So I think based on the reasoning of those decisions that it's possible that a court would apply it to the Sunshine Ordinance, and at least one decision that's not precedential value, the Superior Court in California and San Francisco did that.
Okay, thank you very much.
Member Schneider.
Yeah, just to back that up. I mean, I think it would be unlikely that there'd be a case that would a California state case that would specifically apply the rule of reason to the Sunshine Ordinance. But given the similarities in the Public Records Act regime and the Sunshine Ordinance, and the fact that the same types of concerns apply in the Sunshine Ordinance context as apply in the Public Records Act context, those concerns being, you know, a truly overwhelming request that would sort of shut down or slow down the operations of a government agency, I think it's safe to apply similar reasoning to the Sunshine Ordinance. There probably is not a case that directly does it, but I think it's probably safe to apply similar reasoning.
Can I just speak to that?
Please.
Sure.
You will. No. Please be seated.
Oh.
Please be seated.
Mr. Chair, just through the chair to Member Snyder. But if the Sunshine Ordinance has specific guidelines, that is law, that is a requirement, then how does the implied rule of reason work? I mean, are you saying that it overrides the Sunshine Ordinance's specificities on time frame that something needs to be delivered?
No, I mean, the CPRA has similar requirements in terms of the time that something has to be delivered in and the types of things that have to be delivered. The Public Records Act and the Sunshine Ordinance aren't identical, but there are a lot of similarities. And while there may not be a one-to-one correspondence, I think it's safe to apply the principles of the rule of reason to the Sunshine Ordinance. Whether it applies here, of course, is a completely separate question, and one that I don't think we can answer without some pretty solid facts about what it is the DA's office is doing, and whether what they're doing fits within the rule of reason. But I think the implied rule of reason, you know, with the caveat that I have not researched this area specifically and in any great detail, I think it's safe to apply the principles to the Sunshine Ordinance.
Mr. Chair,
Member Wolf.
My concern about this is I don't know that we can create a gray area when there are implied time frames in both the CPRA and in the Sunshine Ordinance. So based upon the section in Mr. Threet's summary, DC 3's summary under Western Select Securities, Inc. versus Murphy, the last sentence says, while a trial court opinion generally may not be cited as precedent in a judicial proceeding, this trial court opinion nonetheless may shed light on whether a court would rule that the Sunshine Ordinance includes an implied or an inherent rule of reason. I don't necessarily read the Sunshine Ordinance as having an implied rule of reason, except that it offers the respondent additional time to complete a request. That, to me, provides it provides an implication for rule of reason in saying that under the Sunshine Ordinance, we know something may not be able to be delivered within 48 hours or 24 hours. If you notify the complainant within this period of time, you have 14 days. It resolves that issue because these cases were dealt with. Well, the last one was dealt with in 2000, but the prior cases were before even the CPRA. So there was no guidelines there at that point.
May I clarify?
Mr. Three, please.
I just want to be clear that it is the opinion of our office that it does apply to the Sunshine Ordinance, but there's not a case that has precedential value on point. So when I say it's an open question, the courts have not decided it, but it is our opinion that it would apply if it was litigated and it went up on appeal and the case was decided. The other clarification I'd like to make is that, the rule of reason is case law, but nonetheless it is the law. So it has been read into the Public Records Act. After the passage of the Public Records Act, the courts decided it did apply to the Public Records Act, in spite of its specific timelines in the statute. I think I'll leave it at that.
Member Johnson?
I'd like to introduce a second rule of reason because this is an attorney's office, and that is the California Code of Civil Procedure regarding discovery. You have a certain amount of time to respond to discovery. You have 30 days. That's what we do in court. That's what they do all day long. And in light of the fact that the complainant didn't hide the fact that she's from a PR agency, and that Ms. Harris is running for office, they have essentially now circumvented the ability for this PR office to receive documents, and this is 4 months. I can assure you that the district attorney's office would in no way tolerate one of the defendants taking 4 months to respond to discovery. And they are an attorney's office. This is what they do, respond to discovery in appropriate amounts of times. And in fact, criminal law is even more stringent on their office than civil law, which is what I just cited about civil procedure. So they would in no way tolerate 4 months. And a judge would not tolerate the city attorney's office or the district attorney's office taking 4 months to respond to something. And so because it is their job, they are skilled at it. It's not the kind of thing, this is just like a discovery request. It's no different. It's what I've done for 15 years. I could respond to this.
Member Washburn?
In looking over the material that was supplied to Ms. Lanza, I was struck by, my goodness, this could have been produced in several hours' time right after she made the request. What she was sent was really, low-hanging fruit, information that was of direct interest or more important for her, perhaps. There's been nothing after 4 months. So there's the rule of reason applies, both ways, I would think. And I think the complainant has been patient. She was very specific about what she wanted and what she got. Frankly, I looked at it and I said, this is ridiculous. This was so easy to produce.
Mr. Threet, I'm sorry.
Just one further clarification, then I promise I will keep my mouth shut. When I say that our office believes the rule of reason applies in this situation, I don't mean to speak to whether the rule of reason justifies the delay in this case. That's a wholly separate issue. And even if the rule of reason applies here, there are a number of questions that might help in determining whether the rule of reason would justify the delay in this case. And I tried to outline what some of them might be in questions under the category of questions that might assist in determining facts. Because it entirely depends on what the situation is in the district attorney's office and how they're responding and how much resources are required and what the other strains on their office are, whether the rule of reason would justify this or not.
I have a question that I wanted to ask Member Johnson. You brought up before the whole question of discovery and if this were a court case. But this is not a court case, and so can we apply, even though since this is not a court case, can we apply those same rules of discovery?
Well, you're applying case law to it. You're applying case law to it. That's the law. That's court law that you're applying to. But at the same time, my point was not to apply the law. My point was they are very skilled at responding to questions like this. I was not trying to say that they should apply that law. This is their job all day long. They respond. This is very, very similar to any kind of a discovery request. So I was trying to point out, and discovery in civil law is, I mean, you frequently refer to attorneys, even though we're not supposed to have attorneys here. I work with attorneys all day long. And if you have to cooperate within a limit, within a time frame in discovery, and you do a back and forth, and it's based on a specific purpose. Usually in a court case, it would be a hearing. In this instance, it's because she needed this before the election, and she requested it in plenty of time. But my point is that there is a precedence for what goes back and forth, and in civil law, it's 30 days. In criminal law, it's even less. And my point was not really to make it that it's law. My point is that that's what they do. That's their job. So they are skilled at. They cannot say that this would take a certain amount of time. They're not the same as the planning department. They're very skilled at responding to discovery. That's a significant part of all cases.
Thank you. Member Snyder, and then Member Wolf.
I just have a number of questions for Mr. Henderson once the task force is finished with discussion, or whenever that's appropriate.
Whenever you'd like to. It would be appropriate now. Mr. Henderson, please approach.
So, Mr. Henderson, there's a number that you've responded to two of the items on the list that Ms. Lanza submitted. I just wanted to ask you about the first thing she asked for is the titles. So information regarding District Attorney Harris. Titles held, units assigned, and salary and per diem payments from 1998 to present. And that is, I take it, to apply only to District Attorney Harris. That doesn't seem like something that would take a lot of research to figure out. That's less than 10 years. Can you explain why such a delay on this? I mean, all it's asking for is what her titles have been, what units she's been assigned to, and what her salary has been.
I think I know what my office was working on, what my staff was working on was the per diem part of the payments that go back to 1998.
And do you have
what was classified and where those per diems came from and what they paid for specifically?
And so do you have somebody who's been actively working on figuring that out?
Yes.
How often are they putting time into this?
I can't tell you the specific amount of time she's been putting into it, but I know she's been working on it because she checks in with me from time to time just to tell me what she's been doing and how she's been going about getting the information. Part of the issue is, her full-time assignment is handling all of the cases related to our truancy initiative. That's what her caseload is. And I just, to put it in context, because it doesn't make sense without context.
Sure.
So, like, even my misdemeanor lawyers, the average caseload of my lawyers is 699 cases per lawyer. And, that's our core function, obviously. And so certainly this is still assigned to people to work on and follow up with. But I can tell you what has been voluminous and what has been difficult about this request, these requests in particular, is how far back the request goes. As you know, our office has not had computers for very long. So these requests...
How long have you had computers?
We've had computers 5 years.
How many hours a week?
5, maybe 6 years now we've had computers. Before then, it was intermittent as to who had computers, but most of these requests are hand searches through individual files. Our files don't all get retained in the office. We have a storage, so you have to go back and forth into storage.
Has District Attorney Harris, she's worked for the District Attorney's Office since 1998, isn't that right? So, I mean, all of these records are within the district attorney's office authority or purview, correct? No.
She hasn't.
Okay.
Then you don't really have to go
She
back that
was
far.
in 98. She was in the office, and then she left the office. She was in the city attorney's office, and then she won the election, and she came back, and she was in the DA's office.
All right. So at most you would have, well, depending on how you interpret this request, at most you'd have two different departments that you'd have to look at for her per diem payments from.
Right, but correct.
Arguably, you'd really only have to look at the DA's office per diem payments because that seems to be the way the question is phrased.
Correct.
How many hours a week is the person who's assigned to this spending on it?
I can't tell you. I don't want to guess and tell you incorrectly, but part of, again, just to reiterate, part of the reason why we'd asked for the continuance is because the person that could answer those questions is unavailable today. So, and I don't want to guess. I know we've talked about it, and I know when she recovers things, and I sign the letters turning stuff over, that she's been working on it and collecting things. But I don't want to guess or just make something up just to answer you.
What about the official calendar from 2004 to present? That's the third item on the list. Right. This is something, so now we're talking about 6 years. It's a smaller time frame. What's the holdup there?
Again, that I know for a fact because I've seen them working on it, at least for the past few weeks, is a page-by-page thing that they are going through. I know for a fact that they're working on that.
Right.
Doing
How many pages are there in a calendar? There's, 12
I would
months,
imagine
right?
365 for each year, but I don't know what year they're up to.
What is it they have to do to it that takes time? I mean, why can't they just give her the calendars?
Because the way that the calendars are kept by hand, part of her personal staff that keeps the calendar has changed no less than 4 times while she's been in office. They each kept the calendar a little bit differently. So it all had to be compiled and gone through to turn it over. But I know they've been working on that as well. I've actually seen them working on it.
How many hours a week are they putting into that?
I don't know. The person that could tell you would be Katie Miller.
How many?
She's working with them.
How many people are working on that?
On that, no. I know 2. I've seen 2 separate people, not including Katie Miller, working on it.
The number of members of Harris's security detail, including their salaries. What's the holdup there?
I don't know. That's probably a DAI or a police department.
What
Because
do you-
they coordinate that together sometimes and separately sometimes.
So you're saying that the people who are responsible for producing that information are not with the DA's office, they would be with the police department?
Not completely. Sometimes it's the police department that handles her security, particularly when she's out of state or if she's out of the city.
Has someone from the DA's office spoken with the police department about getting these records?
I don't know. I would imagine so, but I can't say for certain because the person that's working on that request isn't here.
How many hours a week is the DA's office spent on this, getting this information?
I can't answer the amount of time that the office has spent on any of these requests because the person that would answer that, I'm not trying to be rude, I'm just trying to tell you, I don't know, and that person that can answer those questions is unavailable today, this evening.
What are you doing to collect and organize all official email to and from Harris from 1998 to present?
I would imagine that a run is being done through DDIS. And again, let me just say, because I'm chief and I know how that process works, I can only speak about the process. I can't tell you where in the process along Katie Miller is in terms of how she's collecting the information, but I just happen to know what that process is from other issues that I've worked on. That is a big deal because we don't control our own computer systems. They're interlinked through DDIS and through the city systems so that we have to make a request for records to be turned over to us. And then once those records are run, we can sort through them and go through them.
Has a request been made to whomever it needs to be made so that you can go through those records?
I don't know.
I wanted to just briefly, and then I'll leave you to your gum pain. I just want to go back to the per diem payments. Are these so? Some of these records are stored on a computer, and some would be stored in paper.
I can't imagine any are on a computer. They might be, but I just know, speaking about my own per diem stuff, when I have to pull something, it literally is like, here's a receipt for an event that I had to go to or a forum that I had to speak at or something, and it's photocopied on a piece of paper, and that piece of paper gets turned into our financial people who make their own records and process stuff through the city. But you have to go through those pieces of paper with receipts taped on them to find the records. If they are scanned, I'm not aware of it, and I'm the chief. I mean, it could be happening under me or around me, and I don't know, but I doubt it very seriously.
But these would all be compiled somewhere in a single file, right? So if I asked for Paul Henderson's per diems, or you, Paul Henderson, asked for your per diems from 2007, wouldn't that be in a single place that you could pull out?
That would make sense. But here's what happens. So if I have to do something, and let's say Muni has a forum on graffiti, and they need me to be there, there's a whole file for my interaction with Muni, and it would be in that file. It's not kept in like a Paul Henderson file because they're stored typically with who's making their payment and who has made the request for someone to travel or to be there or to do something. And so Muni has its own file because they're part of our budget. I don't know if that makes sense, but the reality of it is, so like if I pulled all of my receipts, I spoke this month for the state bar. So it goes into part of there's a section of our budget, I don't know what it's called, but different from the general fund that supplements or goes to the budget from these outside agencies. And these forms, these requests, and these documents are kept according to them because it's the financial people that are keeping those records in terms of how the per diems get reimbursed or paid out front, because that makes a distinction as well. If I pay for it myself out of my pocket, or she pays for something out of pocket, or something is paid ahead of time, determines how and where the records get kept. But it's not kept in like just one file of Kamala Harris per diem. It just isn't.
Is it the DA's office or DA's office contention that any of this per diem information would be not subject to public release?
I would hesitate to answer before talking to Katie about it. I can't think of a reason why. I can't think of a situation where it wouldn't, unless it was something that was personal. But why would we reimburse for something that was personal?
So there's
I
likely
can't answer that question with certainty without talking to Katie.
But what you're saying is that it's likely that there would not have to be extra time spent to redact information or select out information on the per diem.
Oh, that's a very good question. Actually, yes, there would be. So oftentimes, if, let's say, because this happens sometimes when I have to travel or when I'm doing something with the office, I have to turn in to show my receipts like my whole American Express bill or something, because I just paid for it because it was easier and it wasn't set up.
So your credit card number.
Exactly.
Yeah.
I know for a fact that some of her per diem stuff, because as I said, I've also seen them working on that as well. And again, it's a going through everything and redacting some of the stuff, because that's very frequent.
Does the DA's office do self-audits? In other words, does it audit its payments to members?
I'm sure.
To its employees, I should say.
Oh, yeah. Yeah.
It must be an incredibly arduous process. I mean, they have to, during the audit process, you have to pull together all of these per diem. I mean, how do you ever get that done?
I would imagine, and I don't know how they do it because that would be someone else in my office, but I would imagine they put a lot of work in the front end as to how money comes in or how money goes out. I don't know that they do like a sweep every year to see is Paul Henderson abusing his per diem, or is Kamala Harris, was she reimbursed enough from the work that she did with the city attorney's office. But many of our budgets work that way as well. So even interdepartmental, the work that the city attorney's office does with and for our office gets charged to our office. It's all literally case by case on what the actual action is and what the actual agency or individual is externally that's interacting with us and the individual. So it's not just the office. It literally is to Paul Henderson or to Kamala Harris is how it works.
So one final question on this top unit, and then I'll leave you alone. Have you collected the titles held, units assigned, and salary from 1998 to present? Everything, in other words, except the per diem payments?
I don't know. Katie would know that.
It's hard for me to imagine that that's something you couldn't have gotten in 4 months.
I can't speculate on it because there may be some funny thing. I would imagine that finding the salary, it's published in the paper every single year for public employees already.
So why couldn't you give Ms. Lanza the titles held, units assigned, and salary, and hold back the per diem if the per diem is the one thing that's causing the holdup?
I know, and Katie's not here, so I can't guess as to how she's doing it. I know some of these things she has responded to and turned over. I don't know how some things are being parceled out and some not. Maybe she's close to getting the per diems and is turning everything over at once. I don't know because she's not here. I only know that she's been working on it, but she was unavailable today. And I'm really not being defensive and trying to dance around. I just don't want to answer and be incorrect because I'm not the one that's actually working on it personally.
All right.
I mean, I'm not trying to be disrespectful. I'm just trying to be honest. So,
thanks, Mr. Henderson.
I don't want to misspeak.
Member Wolf.
Mr. Henderson, are you aware of Prop G?
Yes.
With regards to calendars?
Yeah. Yes.
Okay. So in 2004, were you in that office?
Was I in that office personally?
Yeah. Were you working in that office?
Yes.
Okay. Were you using CC Notes at that time? Do you recall?
No, we were not.
So how are you managing calendars?
Well, in 2004, I was a line deputy. So.
Well, now you're the chief administration.
I'm
right?
chief now.
Okay. So you have some knowledge. I mean, it's 6 years ago. Do you have any knowledge now that we're doing this investigation? You know, we're getting this the documents. Are you aware of what calendars were available at what time? Like, are the current calendars available?
The current calendars
Under
are
Prop
being
G.
mail available. I still honestly don't know what they were doing 6 years ago in terms of Prop G.
But what about 2 years ago?
I don't know how they were
Okay.
managing.
The reason why I'm saying is because we've had this subject come up for
other agencies.
We're talking department heads,
Mm-hmm.
chief of fire department, the mayor, so on and so forth. You know, and those Prop G calendars are now very well maintained.
Yes.
And they're very separated between what is personal and what is business, so that there's, lots of times there was those complaints. So
I would presume that, but I don't want to say it
I
because I
understand.
don't know for sure.
It's a concern of ours that they're not readily available upon review. Even if somebody walks into the office and says, "Can I see the calendar for today?" Can that be made available?
I can't imagine why it wouldn't.
Okay, so that's where we're getting at here. I was going to ask our legal counsel about what reasonableness limitation means, but to me, as I continue to read both the CPRA and the Sunshine Ordinance, it lends to reasonableness being 14 days upon request. Now, you're required to turn around these documents 10 days after request, and after that, you can make a request of an additional 14 days. That, to me, is reasonable. I'm going to hold that to be true, okay, because reasonable is a vague term. I think I have the answer to what reasonable means with regards to what both state and local law is. Have you notified Ms. Lanza how much more time you will need specifically for each of the documents or for the whole package at this point? The law requires you to do so.
I know that we've been in contact with her each time, and there are a number of letters specifically and directly to her about what we're doing.
Are you aware of any documents? I'm going to ask her too, because she probably is the single point of receipt of a lot of these things. Because you notated, and I see a quote here, that you had invoked the additional 14 days, but that you also said, quote, you'll handle one request at a time. So if you're going to handle one request at a time, you need to notify her when the expected delivery is going to be. Have you done so?
I believe we have, but again, the person that's working on this directly isn't here.
Okay, well, that presents a problem. Are you? Then the next question is: Are you prepared to be able to answer all these questions?
No.
Okay, so that poses another issue for us that we run into a lot. That the wrong person is sent to answer the job, to answer the questions. So
that was exactly why we requested the continuance, so Katie Miller could directly address.
Did you know? When did you notify our office of a continuance?
Weeks ago, more than 2 weeks.
The request for continuance by the respondent was made at the complaint committee hearing 2 weeks ago.
Okay, and so was the continuance afforded?
It was not the proper form.
It wasn't the proper form for the continuance.
No, we decided this evening not to continue.
Okay, then I'll forego that line of questioning. My next question is, are you aware of 6727, Sunshine Ordinance?
Yes.
Justification withholding. So withholding under specific permissive exemption under the California Public Records Act or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. Have you cited that authority?
I don't know.
Okay. So I just want you to be aware of the California Public Records Act 6253, okay, in the middle where it states when this is after your request for an extension of 14 days when the agency dispatches the determination, and if the agency determines that a request for more time the request seeks disclosable public records, the agency shall state the estimated date and time when the records will be made available. Okay? So I just want you to be clear that this is not just cited in one section of the law, but in several sections of the law. In that same section, 6253D, nothing in this chapter should be construed to permit an agency to delay or obstruct the inspection or copying of public records. And no notice shall specify a date that would result in an extension for more than 14 days. And so to me, the implied rule of reason and with regards to reasonableness limitation is, to me, has been extended. So I want to ask Ms. Lanza one question. If you don't mind, you can
Ms.
relax.
Lanza, please approach.
Thank you.
I
totally understand.
Mr. Henderson, please
I'm
be
done.
seated.
I'm going to turn
Mr. Henderson, please be seated. Ms. Lanza?
So, Ms. Lanza, have you received any notices from the DA's office as to when exactly, date or time, you will be able to receive any of this
I've been
information?
told time and time again that because my request is so large, they can't speculate or give me any time frame. And they cite again and again the case law that was talked about earlier, that if it interferes with their normal job, they will take their time to do it, or they won't do it until they have time.
Okay. So I'm wondering if you can respond to this partial statement here. The custodian shall inform the requester of the nature and extent of the non-exempt information and suggest alternative sources for the information requested. Was there any exempt or non-exempt documents that you requested that they told you was not available to you?
No, not yet.
Not yet. Okay. Okay, that's. I think that's all the questions I have. Thank you, Mr. Chair.
Ms. Lenz, if I could ask you just one question. Have you received any information regarding the titles held, units assigned, or salary of Ms. Harris?
No, I haven't.
And I take it no information about the per diem payments either?
No.
Thank you. Please be seated. At this time, the respondent and then the complainant will each have 3 minutes to issue any concluding or rebutting remarks. Sir, do you know if Mr. Henderson is still with us?
Again, Seth Stewart from the DA's office. Mr. Henderson mentioned that he had to leave. I would assume it has to do to his current status that he just had surgery on his mouth.
Thank you. Do you have any concluding remarks you'd like to make, sir, or rebutting remarks?
I do not.
Okay. Thank you. Ms. Lanza, you have 3 minutes.
Thank you. The only other thing I'd like to add is that in the same time frame, I requested information from 2 other city agencies and received responses within a few weeks. One of them was nearly identical to this one. It only was a request to the mayor's office, so there were a few slight changes to it. And it took them a month and 4 days to respond to me, but when they reached the threshold of that 10 days and then that 14 days, they called me and said, it's almost ready. We'll have it to you next week on a disc. It'll be done. So that was the only thing I wanted to add, is that 2 other offices were able to respond to me with the same requests in the same time.
Thank you.
Thank you.
Matter is back with the task force. Member Johnson, Member Snyder.
I can't exactly recall if anybody pointed this out, but I would like to draw your attention to, again, I know people don't appreciate all of the time what I'm saying, but an attorney's office spends all its time responding to these requests. That's what they do. It's not big, sexy issues. But 67.25D, immediacy of response, requires that the city and county shall produce any and all responsive public records as soon as reasonably possible on an incremental or rolling basis, such that responsive records are produced as soon as possible by the end of the same business day that they are reviewed and collected. Of course, they ask for the 10 days, but they would still be required to do it on a rolling basis, and it's to prevent them from keeping the documents that are requested from being useful to the requester. And clearly she wanted these before the end of the election cycle, and they're no longer useful. And so they've circumvented the whole purpose. All of this other stuff about how they keep them and how long it takes, 4 months is more than adequate time for departments that don't deal with discovery on a regular basis. And these people do it all the time. And on an expedited criminal law is considered even more expedited than civil law. And that's what they're used to. And this is more like a civil case. 4 months is a long time. So, thanks.
Member Wolf.
I would just say that, if we're dealing with if the complaint is dealing with a time frame, and they're really looking to get these documents, which are way overdue, and they're dealing with a deadline that's like several days away, I think you have injunctive relief. You can go to a court tomorrow, and you can get injunctive relief and a writ of mandamus to force them to give you the documents. And they will have then a court order. I mean, we don't have that kind of power. We will make a determination. We don't even have enforcement power here. So, it's we will identify the violation. That's what our purpose is, and that's to the extent of what we have the power to do. So, that's extended to you. It's contained in the Sunshine Ordinance. It's pretty explicit on how to do it, and that would be. Beyond our determination, if we come to one, that would be at this point, if you're dealing with a deadline, I wouldn't wait for the Ethics Commission.
Member Snyder?
So first, it seems apparent to me that the implied rule of reason applies here and applies to the Sunshine Ordinance. I'd agree with the city attorney's position on that. Applies generally to the Sunshine Ordinance, I'm saying. So the next question after one decides that the implied rule of reason applies here is to ask whether or not the processes which the DA's office is using to get the information fall within that rule. And if what they're doing to get the information is reasonable, then it might justify delays that otherwise would have them in violation of the Sunshine Ordinance. So the questions I asked were aimed at determining what the processes the DA's office has put in place, if any, in order to get this information to Ms. Lanza. And to the extent Mr. Henderson was able to answer the questions, and I understand that he's not the person who knows all of this in intimate detail, but he knew enough and was able to tell us enough that it seems clear to me that there are a number of items on the list that could have been easily and reasonably produced much sooner than 4 months. Maybe not everything on the list, but there's nothing in Ms. Lanza's request or in the Sunshine Ordinance which says that they have to have everything before they produce it. And in fact, the DA's office themselves have produced it seriatim, so they've given two of the 10 items, and they're producing it as it comes. In sum, it seems apparent to me that given the rule of reason, even given the rule of reason, the DA's office has taken the DA's office has not put in place procedures which indicate that they are working with reasonable diligence to produce these records to Ms. Lanza, and I would therefore move that the DA's office is in violation of 6721, 6725, 6726, and not. I don't think 6727 really applies, but I'd be open to persuasion on that. I don't think it fits here, but those three, 21, 25, and 26, I believe do.
Is there a second? The chair will.
I'll second it, but I would like to have 6727 added, and I'll make my case for it.
Okay. Well, okay to the case for being made for it.
Okay. So, Mr. Chair, if I may.
Please.
So, in let me see, what section is that? It's in the Public Records Act. I have to find it under the Sunshine Ordinance, but I'm sure it's in here. The statement in 6253, it says each agency upon a request for copy of records shall within 10 days from the receipt of the request determine whether the request in whole or part seeks copies of its global public records in the possession of the agency, shall promptly notify the person making the request of determination and the reasons therefor. When the agency dispatches the determination for an extension, they need to notify them explicitly the reasons why they cannot do that. And it has to also notate the names and the titles of the position of each person responsible for the denial, if there is a denial. And it also speaks to unusual circumstances, which I didn't hear any unusual circumstances. So my feeling is that under Sunshine, I guess it's under 6727.
I mean, 6727 deals, I think, with situations where the city agency has withheld the information on some basis, either a statutory basis, right, a specific exception in the California Public Records Act, on the basis that it would incur civil or criminal liability, and then it provides 6727 provides requirements for disclosure of an explanation to some degree of the reasons that the withholding has happened. They haven't really withheld in the sense here, I don't think, in the sense that 6727 envisions. They just haven't produced. They haven't said, we can't give you these records. Because 6727, the idea is, I think, the idea is if they tell you they can't give you the records, they need to explain why. And the reason for that is that so you can challenge them and if you want, and so that it's out in the open why they're not giving the records. They haven't really done that here. They haven't said we're not giving you the records because. They're saying we're working, we'll get you the records, we'll get you the records. So I just don't think it fits here.
Except in A, there is no specific permissive exception.
Right.
So it's not justified. And where permissive exception is not forbidden to be asserted, they shall cite the authority. That's why I asked them the question.
Yeah.
If he can cite the authority, and there is none. You know, you can't claim necessarily that the case law is citing an authority for permissive exemption. That's only for the case law is specifically applied for implied rule of reason. It's not necessarily for specific permissive exemption, and to me, sounds like what they're asking for by implication. It's like, we'll give it to you on an item by item basis because we don't have the time.
Yeah, but none of that doesn't fall under any of those.
Or we're too busy.
Yeah, I mean, they're not saying we won't give it to you because it's exempt under the CPRA. They're not saying we won't give it to you because it's.
I think
they're just not giving it to them.
I know, but but this is the crux of it. It's the justification for withholding. They
haven't even.
They don't have
one.
a justification
Right.
for withholding, so they are. To me, they're in violation of 6727 because it doesn't really.
I think 6726 gets more.
I agree
better
with you.
At what you're saying.
I agree with you there. But there is no. But even under 26, it states in the middle. Information that is exempt from, but it talks about exemption. Well, I guess it's exemption from disclosure.
As I read,
that's the redaction.
As I read 6727, though, 6727, I believe, involves a stated intention to deny a record permanently. Not to delay providing it, to deny it permanently.
Okay.
And I don't see that applying here.
Okay. Okay. All right. Then I'll withhold that, and let's move ahead on the other three items.
Okay. There is a motion to find violation of 67.21, 67.25, and 67.26. I would like to add 67.21E. And here is my reason for it. This complaint was filed on September 2nd. And although Mr. Henderson is not necessarily in possession of the facts of all this case, he has had more than a month and a half to go after them, to find out who is working on finding what record, and since he is the respondent in this case, to come to the task force prepared to give us more answers than I think he has. And I think a 67.21E violation has occurred here. I offer that as a friendly amendment. Does the second accept? Does the maker of the motion accept?
Yeah, and actually, I think I said 6721, but we should probably, you're right, specify E. And furthermore, on
B, I believe B applies. B for
B,
beta.
B and E, 6721B and 67. Okay, yeah. 6720. 1 second.
I mean, you can go. You can even say C. I mean, I don't know if she actually. I mean, I'm not. I'd have to speculate because we have to ask a question. Yeah.
And just to further clarify, I don't think I specified a subsection for 6725. I believe it would be 6725D,
Okay, so we have, have we added 67.21C?
Yeah. No. I mean, it's okay. I would have to. I'd have to ask more questions.
B&E.
I think it covers.
Okay. So we have 67.21B and E, 67.25D, 67.26. Is there public comment on the motion?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I think you're really on track with this. There are multiple violations here. I'd just like to address a couple of things Mr. Henderson presented. I lectured for the University of Hawaii for 14 years, and I lectured at all the different campuses, 3 campuses on Oahu, 2 on the Big Island, and so forth. And every one of those trips required separate documentation that I would turn into them, but they would always issue me 1 check every month. And so if somebody wanted to say how much money did Ray Hartz get from the University of Hawaii, they would be able to tell you instantly. Now, if you wanted the specifics as far as where that money came from which community college, which campus of the community college, or so forth, that would take more research. And it sounds like what he's saying is because we have the system that has a lot of moving parts and the input is all multifaceted, that means the output it has to be too. And it isn't that way. Because, again, every company that I've worked with, whether it was a government organization or a private entity, would always issue me 1 check a month. They didn't issue me a check from this fund on Tuesday and from that fund on Wednesday and another fund on Thursday. It economically makes no sense at all. The second thing is Mr. Henderson shows up, and I don't know about you, but if you worked for me and I had assigned you a responsibility, and now I get a notice and I know I'm going to have to go tonight and answer for your work not being done, I'm going to have you in my office that day and say, okay, I want to know exactly what is the status, what's going on, and I would be asking most of the same questions you had asked, and I would be saying, I'm not happy with this because I now have to go before them and answer questions that I can't answer. I have to try to justify something I don't have any way of justifying except say I don't know. And I would be saying to you, I'm not happy with this because I'm not happy simply with the fact you can't answer these questions for me, let alone that you now expect me to go out in a public forum and look like an idiot because I have no idea what's going on in my own department. And I think that's really the crux of this matter is all the questions you're asking are questions that should have been asked by the person who was here answering questions. And everything he said was, I don't know, I couldn't say, I don't want to say because I might be wrong. And I have to honestly ask, did he talk to these people knowing that he was going to be here tonight, and did he get answers from them and accept the same answers he gave from you? I find that rather hard to believe. I know I wouldn't, and I doubt seriously any professional would.
Thank you. Further public comment on the motion?
Yes, Commissioners. I just want to say I agree with Mr. Hartz. And also the gentleman that was up here, he was saying that, was it Kathy or something that had us all the answers? I wonder what would happen if Kathy left or something. I guess that department would have to close down. I mean, this is ridiculous. The other thing I wanted to point out is that, let's see. Now it escapes my thoughts here. Oh, boy. I'm lost. Oh, yes. What I was going to say is that if Ms. Harris took Ms. Lanza's list and told their staff, I need this filled out because I need it for my campaign or something like that, I'll bet it'd be filled in 4 hours. That's all I have to say.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion on the motion? Member Johnson?
I have a friendly amendment. I'm not sure if it's a good idea or not, but Member Wolf had brought it up. Section 67.29-5 requires that public calendars shall be made available to the requester within 3 business days subsequent to the calendar entry date. And since she asked for calendars and they're claiming that they can't produce them, I'm wondering if we can add that as well.
Second accept. Maker accept.
Let me just look at it really fast.
As part of the respondent's public testimony. In admission.
Yeah, I agree.
Okay, so the motion now reads to find violation of sections 67.21B and E, 67.25D, 67.26, 67.29-5. Further discussion.
Can I ask a question of Mr. Threet?
Member Snyder, Mr. Threet.
Mr. Threet, is there anything we should do on this motion to make it more to make it complete and full? Is it enough to just say the section number and the subsection, or should we provide further justification, or what's the proper way to have this motion put in?
Through the chair, I think the way the motion is made now is sufficient. However, to make it as strong as possible, the task force should make findings of fact that support the violations and explain as well as possible how those facts fit the sections that you're saying are violated.
So do we do that as part of the motion, or do we do that prior to?
Let me ask through the chair, is the concern about what will happen? It goes up on enforcement, or what is the focus of your concern? It will help me answer the question.
Yeah, I just want to make sure that we have as complete a record here as we should, and as the task force ordinarily does.
Even without findings of fact, the record that is provided by the recording of this hearing will provide some support. The support would be stronger if you explicitly say these are the facts that we found based on this hearing that we're relying on for the violations.
So is just saying that sufficient so that it's set into the record, or should I amend the motion to include a set of findings of fact?
So long as the record shows that those are the findings that you've made, I think that's sufficient. But for the efficiency of whatever body is looking at this later, it's probably preferable to have it in a written form.
The chair would like to point out that the facts are also laid out in the order of determination.
Right.
Further discussion. Roll call, please.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Knebber, aye. Member Wolf?
Aye.
Wolf, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 6 ayes.
Thank you. That concludes. This matter is referred to the Compliance and Amendments Committee.
Mr. Chair.
Member Wolf?
Fortunately, I do have to leave. I've overstayed myself.
Okay, Member Wolf has to leave. Member Chan has already left. Therefore, regrettably, most regrettably, and with apologies to those whose items have not yet been heard, we must adjourn this meeting for lack of a quorum. The chair wishes to inquire. Perhaps I should do this by email, but could we hold a special meeting 2 weeks from tonight on November 10th? There are a number of minutes that we have to attend to, and it would move these other items up by 2 or 3 weeks, 3 weeks actually, if we held a special meeting on November 10th. I will not ask for an answer or reply right now, but I will query the members by email. Member Wolf?
I would just say that, I think it needs to be kind of mandatory, because if I can't make it, and considering, the nature of what's happened tonight, still not going to have quorum. So I would make the urgency of this really important.
Well, we have some members who are not here tonight. Maybe they can make it. Okay. Member Knebber.
Just to be clear, you mean the 9th or the 10th, Tuesday or Wednesday?
Wednesday,
okay,
November 10th. Okay. Member Wolf, I would respectfully suggest and request that with respect to item number 8, the Clark versus Mayor, Board of Supervisors et al., would you be willing to make the initial draft of the memorandum to the Board of Supervisors?
Yes, I will.
Thank you. Motion to adjourn.